siap mewujudkan visi misi UNES untuk menyiapkan para ahli hukum yang unggul. Hukum UNES telah memperoleh capaian akreditasi A. Mahasiswa-mahasiswa terbaik Fakultas Hukum UNES terus mengukir prestasi yang membanggakan karena didukung kerjasama dengan berbagai lembaga, baik di dalam maupun di luar negeri, sebagai bentuk peningkatan kualitas akademik dan perwujudan visi dan misi fakultas.
One of the subjects I'm teaching in the Faculty of Law is Theory of the States. Here I discuss with the students some topics including the definition of the states, the essence of the states, and the rule and the function of the states, and also the forms of the government. Not only we discuss about the theories, we also trying to apply those theories into some cases. For example, we discuss about the United States, America. So here we discuss about the forms of the government and also the history of the United States, and then try to compare those case of United States with other cases. For example, the case of United Kingdom, Singapore, and also Indonesia.
Proud to be a part in the law faculty in Semarang State University and able to fight in the international competition. My happiness is to meet another friend, share the new ideas, and discuss about the legal current issues. And my pride is to be part in the law school, understanding about current issues and understanding about the law, politics, and government.
I'm very happy and surprised to study in this university to get Faculty of Law. There's a lot of thankful for all of lecturers who share us their experience to find our team and to achieve our goal. Thank you for all of my friends. Thank you for this university to get me a chance to prepare my future and to be an excellent student from this university. Thank you.
Hi, my name is Faisal Aditya Bagaskara and I studied in Law Faculty. It is very amazing that I can study in Faculty of Law UNES, especially become the part of international class. It's such a nice place to study in here and the neighborhood is very friendly and you can find it's very nice. So I hope from here that I can get the jumping stone for my better future. Thank you.
Halo, apa kabar? Nama saya Adrianus Adida Roman Satrio. Saya biasa dipanggil Sandi. Saya adalah mahasiswa Fakultas Hukum UNES angkatan 2008. Saya sekarang bekerja di Konsul Jenderal Republik Indonesia di New York. Saya teringat waktu saya belajar di Fakultas Hukum Universitas Negeri Semarang, walaupun gedungnya tidak sebagus sekarang, namun dosen-dosennya di sana semua sangat membantu, selalu memberikan ruang dan media berdiskusi untuk kami memahami mata kuliah. Dan juga ikatan antar mahasiswa sangat erat sehingga kami dapat saling mengerti bersama dan sukses bersama. Oke, Viva Justicia.
Saya di Fakultas Hukum mengajar hukum tata negara, khususnya hukum acara MK. Dalam buku saya yang pertama kita kembangkan teori MK dari negatif legislature ke positif legislature, yang intinya putusan MK bisa bersifat mengatur. Ke depan saya akan mengembangkan teori baru lagi, yaitu Mahkamah Konstitusi dalam perspektif social equilibrium, yang intinya bahwa putusan MK kita seimbangkan antara porsi keadilan, kemanfaatan, dan kepastian.
Menjadi fakultas hukum yang berwawasan konservasi, bereputasi internasional berkarakter Pancasila, merupakan kecerdasan untuk merespon revolusi industri. Mahasiswa harus memiliki literasi big data, digital, kemanusiaan. Kemanusiaan ini tidak bisa dibentuk seketika tetapi melalui proses pembelajaran di Fakultas Hukum. Sehingga mahasiswa harus berprestasi, berkarakter, dan berketerimaan kerja. Disinilah percepatan untuk mahasiswa dengan fasilitas Fakultas Hukum UNES memiliki 8 gugus, 8 klinik hukum, dan memiliki 9 pusat studi. Bahkan kita berakreditasi A dan memiliki rombel internasional. Dengan percepatan lulus di dalam kampus Merdeka, belajar Merdeka, kita akan efektifkan semester genap 2020. Mari hebat menjadi penegak hukum bersama Fakultas Hukum UNES.
Good morning, ladies and gentlemen. Before we begin, I will read the guidelines for our conference today. For participants, please make sure you open your camera and mute your microphone for the sake of enjoyment of this event.
Next, do not send the webinar Zoom meeting link to anybody who has not registered for this webinar, since we are going to remove uninvited attendees.
The next, attendees have to fulfill the attendance list as an obligation to get the e-certificate, and the attendance list will be given in the middle of first panel session and second panel session. Make sure you fulfill both the links. Therefore, you need to stay tuned and do not skip speaker's presentation.
If you have any question during the presentations, you can use the chat room feature, and you have to mention your identity and to whom you are addressing your question before you send your question. Some questions will then be read out in the question and answer part of the session and answered live by the speakers.
The last, if you have further inquiries, do not hesitate to contact the committee through chat. Okay, good morning, ladies and gentlemen. Welcome to the 4th International Conference of Indonesian Legal Studies 2021 with the theme, The Re-establishment of Law, Economics, and Health System After COVID-19 Pandemic. I'm your host, Martinda Intan Permatahati.
And Imam Adi Nugroho, and I'm very happy to meet all the participants. And it is honor to me to welcome among us here, we have the Honorable Rector of Universitas Negeri Semarang, Professor Dr. Faturuman M. Hum, the Honorable Dean of Faculty of Law and all of the Executive Board.
And please give a warm welcome to our keynote speaker, Professor Dr. Mahfud MD SHSU MAP, Coordinating Minister for Political, Legal, and Security Affairs of the Republic of Indonesia. And we are honored to have our invited speakers, the Honorable Professor Dr. Tima Drinoksi from Faculty of Law, University of Pax, Hungary, the Honorable Professor Mary Sainsbury from Canberra University,
and we are honored to have the Honorable Dr. Siti Hafsyah Idris from University Teknologi Mara, Malaysia. Selamat pagi. The Honorable Professor Jeko Barhuizen from University of Limpopo, South Africa. Good morning, sir.
And also the Honorable Professor Dr. Martita M. Hum from Universitas Negeri Semarang, Indonesia. Dear Excellencies, distinguished guests, ladies and gentlemen, before we begin, I would like to request to all participants to stand. Let us sing the national anthem of Indonesia, Indonesia Raya. Ladies and gentlemen, please rise. Thank you, and please be seated.
Ladies and gentlemen, now it is time to pray together. And I ask all the participants and audience, pray, begin. Thank you.
Ladies and gentlemen, the next agenda is the Dean's Report for Dr. Rodia, SPD SH MSI. The time is yours.
Assalamualaikum warahmatullahi wabarakatuh. Good morning, selamat pagi, salam sejahtera untuk kita semua. Welcome to Faculty of Law Universitas Negeri Semarang. Greetings and warm welcome, Coordinating Minister for Political Law and Security Affairs, Professor Mahfud MD, Profesor Dr. Fatur Rahman, Rektor Universitas Negeri Semarang, Profesor Mary Sainsbury from Faculty of Law, University of Canberra, Australia, Professor Jacob Brahuizen from Department of Criminology and Criminal Justice, Universitas from Limpopo, South Africa, Professor Tim Green-Konzi from Faculty of Law, University of Pek, Hungary, Siti Hafsya from University Teknologi Mara, Malaysia, Profesor Martita Negeri Semarang, Indonesia. Faculty of Law Universitas Negeri Semarang has successfully held the last 3 ICIL in 2018-2020 by inviting several legal experts from different continents. And now the 4th ICIL 2021 provide a different perspective in the study of contemporary legal issues around the world. My best wishes to become academic relation event among Faculty of Law, strengthening of the development of legal studies in the worldwide perspective, and the result of this conference contribute to scientific publication. I would like to take this opportunity to express my gratitude to all participants, presenters, speakers for all support, cooperation, and contribute to the 4th International Conference on Indonesian Legal Study 2021. Being grateful in the highest morality manifested by commitment and integrity of law. Thank you very much. Terima kasih. Wassalamualaikum warahmatullahi wabarakatuh.
Ladies and gentlemen, it is an honor for us to have our Rector of Universitas Negeri Semarang in this special event. Our Rector will give a welcoming speech and officially open this webinar. Please welcome Profesor Dr. Fatur Rahman M.Hum.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Good morning ladies and gentlemen, selamat pagi, semangat pagi, semoga berkah dalam menjalankan amanah yang sama-sama kita hormati, kita muliakan Menteri Koordinator Bidang Politik, Hukum, dan Keamanan, Bapak Profesor MD, yang saya hormati para pimpinan UNES, terkhusus Dekan, dan seluruh jajaran pimpinan di Fakultas Hukum Universitas Negeri Semarang, the honorable distinguished speakers, Professor Mari from Australia, Professor Jaco Bakhuizen from South Africa, Professor Timia Trinosi from Hungary, Dr. Siti Hafsah from Malaysia, dan Profesor Martita from Faculty of Law Universitas Negeri Semarang, Indonesia. And all of distinguished participants, seluruh peserta yang saya hormati, on behalf of Rector of Universitas Semarang, I wish to welcome you all to the 4th International Conference on Indonesian Legal Studies. Saya memberikan apresiasi yang tinggi kepada Fakultas Hukum Universitas Semarang yang memiliki inisiatif untuk menyelenggarakan seminar yang sangat relevan. Tema ini dengan situasi global saat kita menghadapi pandemi, tentu kita tetap harus menjaga sehat, namun kita juga harus bisa mengembangkan kegiatan yang produktif, terutama di dalam pengembangan keilmuan. Bidang hukum adalah bidang yang menarik untuk terus dikaji di dalam berbagai pengembangan di keilmuan di dalam situasi apapun, termasuk di dalam situasi pandemi ini. Yang kedua juga tema ini sangat relevan dengan visi Universitas Semarang menjadi universitas yang berwawasan konservasi dan bereputasi internasional. Konservasi memiliki arti bukan hanya mengkonservasi fisik dan lingkungan, tetapi juga mengkonservasi nilai. Nilai yang utama untuk kita konservasi adalah nilai keilmuan dan juga nilai-nilai karakter yang di dalamnya adalah keadilan. Pengembangan hukum di situasi pandemi adalah juga menjamin keadilan bagi seluruh masyarakat di Indonesia dan juga dunia. Hukum bermuara kepada keadilan. Karena itu sekali lagi saya menyampaikan selamat dan sukses kepada seluruh peserta untuk kita mengikuti acara yang luar biasa. Dan mudah-mudahan ini bisa memberi peran di dalam pengembangan kapasitas keilmuan di Universitas Semarang dan juga sumbangsih Indonesia kepada dunia melalui pengembangan hukum yang menjadi bagian dalam kolaborasi keilmuan pada masyarakat dunia. Sekali lagi terima kasih dan selamat untuk semuanya, salam sehat dan berkah selalu. Assalamualaikum warahmatullahi wabarakatuh.
Ladies and gentlemen, now it's time for photo session before we have our keynote speech. And please open your camera for all the participants for about 5 seconds so the committee can capture your pose. I will count it from 5, 4, 3, 2, 1. Thank you. Ladies and gentlemen, next let us welcome our keynote speakers to give speech for Coordinating Minister for Political, Legal, and Security Affairs of the Republic of Indonesia, Professor Dr. Mahfud MD. The floor is yours.
Saya Mahfud MD, Menteri Koordinator Bidang Politik, Hukum, dan Keamanan. Dengan ini mengucapkan selamat atas diselenggarakannya the 4th International Conference on Indonesian Legal Studies 2022 di Universitas Negeri Semarang. Mudah-mudahan konferensi ini memberi kontribusi bagi lahirnya ide-ide pembaruan hukum di berbagai negara umumnya dan di Indonesia khususnya. Tema yang diambil di dalam konferensi ini sangat relevan dengan keadaan yang sedang kita Indonesia maupun dunia hadapi saat ini, yaitu masalah COVID-19. Tepatnya tema ini adalah the re-establishment of law, economic and health system after COVID-19 pandemic. Selamat.
Ladies and gentlemen, now this is the time we are waiting for. We are going to have our first speaker session and we have our moderator here. But before that, I would like to let you know about brief information about the moderator. Mrs. Irawati PhD teaches at the Faculty of Law, Universitas Negeri Semarang. She took her undergraduate degree at the Faculty of Law, Universitas Gadjah Mada, Yogyakarta, her master's degree in law at the University of Indonesia, and Doctor of Philosophy degree at the University of Canberra. The experiences of writing textbooks, modules, or teaching materials began when together with the several lecturers of the General Courses Department wrote teaching materials for Pancasila and citizenship education. After that, she participated in writing the book of principal materials on criminal law and criminal procedure law of the Open University for the Pancasila and Citizenship Education Study Program, and textbooks for civil law and civil procedure law, and wrote several articles in journals and proceedings. In February 2020, she was invited as a visiting scholar at Charles Darwin University, Australia. Ladies and gentlemen, Mrs. Irawati PhD, the floor is yours.
Akan ada masa di mana kita menjalin rasa manusia dengan semesta. Mendaki ke puncak tertinggi, menggapai tujuan dengan kerja keras dan strategi. Perjalanan mengajarkan banyak arti dalam setiap langkah yang terlewati. Bercerita lewat asa untuk terus dijaga.
Manusia sejatinya berencana, menata cita-cita dalam bingkai rencana. Percaya bahwa keindahan tercipta bukan instan, melainkan lewat prinsip dan pedoman. Kreativitas dan imajinasi saling berkolaborasi, mengasah naluri, menjamah potensi. Tak akan bertemu ujung untuk apa yang kami kejar. Tak akan tercipta rasa tanpa belajar. Apa yang kami lakukan berawal dari sebuah ilmu yang kami emban di rumah peradaban, Universitas Negeri Semarang.
Kemajuan kita sebagai bangsa tidak bisa lebih cepat daripada kemajuan kita dalam pendidikan. Pikiran dan wawasan menjadi sumber daya fundamental.
Di sini saya belajar banyak hal, seperti mempertajam kecerdasan, memperkukuh kemauan, dan memperhalus perasaan.
Pendidikan adalah senjata paling ampuh untuk mengubah dunia, termasuk Indonesia. Berangkat dari mana? Ya dari diri kita sendiri.
Inilah rumah ilmu pengembang peradaban, tempat tunas penuh talenta tumbuh bermekaran dalam kasih sepenuh hati, bertumbuh menemu arti. UNES Gemilang untuk Indonesia Maju.
Kegemilangan memandu UNES dalam melahirkan generasi berkarakter dan berprestasi, agar tunas muda Indonesia bertumbuh, menemukan peran dan makna demi kejayaan Indonesia dalam peradaban dunia.
Setia mengawal semangat perubahan demi kemajuan bangsa dan peradaban. Sebab kami percaya niat baik saja tak cukup. Denyut inovasi harus terus berdegup. Arum luhuring pawiyatan ing astoniro. Semangat ini berdiam di hati, terpatri di jiwa kami.
Selamat datang di Universitas Negeri Semarang.
Gemilang untuk Indonesia Maju.
Selamat datang di Universitas Negeri Semarang. Gemilang untuk Indonesia Maju.
Assalamualaikum.
Minumnya jangan dimunculkan soalnya kita nggak dibayar.
Ladies and gentlemen, thank you for preparing yourself to join our seminar. Assalamualaikum warahmatullahi wabarakatuh. Good morning, good afternoon to you all. The respectable the Dean of the Faculty of Law, Universitas Negeri Semarang, Dr. Rodiah, the distinguished invited speakers, Professor Tima Drinotsi from University of Pax, Hungary, Professor Marie Sainsbury from University of Canberra, Australia, Professor Jeko Barhuizen from University of Limpopo, South Africa, Dr. Siti Hafsyah Idris from University Teknologi Mara, Malaysia, and finally our beloved Professor Martita from Universitas Negeri Semarang, Indonesia. The Honorable all academics and administration staff of the Faculty of Law, Universitas Negeri Semarang, the Honorable all authors and participants. My name is Irawati. It is an honor for me to become the moderator for today's seminar. ICILS, or International Conference on Indonesian Legal Studies, is an annual academic event held by the Law Faculty of Universitas Negeri Semarang, which was started in 2018. This year is actually the second time for the seminar held online. It is due to the COVID-19 pandemic. So considering the situation and condition we have been facing for more than a year now, we hope through this seminar, we would have a fruitful academic enlightenment to prepare ourselves in regards with law, economic, and health systems, as the theme of the seminar is the re-establishment of law, economic, and health systems after COVID-19 pandemic. So ladies and gentlemen, we have 5 invited speakers today who join us from 4 continents. For the first session, I would like to greeting from Asia. We have Professor Martita. Hello, Professor. It's nice to have you today. And from Australia, I hope Professor Sainsbury have already joined us. Hello, Professor. Oh.
Hello, hello.
Hello, Professor Sainsbury. How are you?
I'm very well, thank you.
It's nice to see you again, Professor. Thank you so much for joining us today.
Thank you for having me.
Thank you. And from Europe, we have a speaker from Hungary, but I understand that Professor Tima Drinotsi is joining us from Brazil right now. Hello, Professor Tima Drinotsi. How are you?
Hello, good morning, good afternoon, good evening for everybody. I'm fine, thank you.
Thank you for joining us today, Professor Drinotsi.
Thank you for the invitation.
Thank you. So, ladies and gentlemen, we have 2 panels. For the first panel, we have greeted our speakers, Professor Tima Drinotsi, Professor Martita, and Professor Marie Sainsbury. While on the second panel, we will have Professor Jacob Barhuizen and Dr. Siti Hafsyah Idris, who will join us later in this afternoon. So we expect every speaker to deliver speech maximum for 30 minutes. And for the audience, we welcome your question and comments. Please write it down at the chat box and I will read them for you. And the Q&A session will be given time after each panel. So before we begin our first panel, please allow me to read our speakers' curriculum vitae for the first panel. We will start with Professor Tima Drinotsi. She is a visiting professor at the Faculty of Law at the Federal University of Minas Gerais, Brazil, a professor at the University of Pax, Faculty of Law in Hungary. She defended her PhD in 2006 and her habilitation monograph in 2010. In 2017, she was awarded the title of Doctor of the Academy of Sciences of Hungary. Professor Drinotsi has been a visiting professor in some law schools, among others in Czech Republic, Poland, and Germany. She also serves as a professor at the Kenyatta University School of Law in Nairobi, Kenya in 2018 and 2019. She has her newest co-authored book, also will published by Routledge, is coming out this September and entitled Illiberal Constitutionalism in Poland and Hungary, the Deterioration of Democracy, Misuse of Human Rights, and Abuse of the Rule of Law. Besides illiberal constitutionalism, her research interest covers constitutional change, constitutional identity, and the quality of legislation. And for the second speaker, we have Professor Martita from the Faculty of Law, Universitas Negeri Semarang, Indonesia. She took her doctorate degree in law at the Universitas Diponegoro. And she also had a sandwich-like program at the Law School of the University of Wisconsin, USA. Her master's degree in law was taken from the Universitas Hasanuddin, while her bachelor degree in moral and civic education from IKIP Semarang, or we can also call it Institute of Teaching and Education Science. Her research areas, among others, in legal system, human rights, constitutional, and constitutional court. At the moment, her current position at the management of the Faculty of Law is as Vice Dean for Academic Affairs. Her publications, among others, some books, the titles, Hukum Keterbukaan Informasi Publik di Indonesia or Public Information Transparency Law in Indonesia, and her articles such as Why Legitimacy Matters in Times of Uncertainty, a critical study of the success story of the Constitutional Court of Indonesia. And for the third speaker, we have Professor Marie Sainsbury. It is such an honor for me because Professor Sainsbury was my supervisor when I took my PhD degree. She comes from Canberra Law School, University of Canberra, Australia. Her educational background, she got her higher degrees from the Law School University of Tasmania, which are Doctor of Philosophy in Law and Bachelor degree. And her research areas, among others, copyright history, design laws, and moral rights. Her current position is as Acting Associate Dean Education of Faculty of Business, Government, and Law. Her publications, among other books, such as Indigenous Cultural Expression and Registered Designs, and 4 articles, such as The Power of Visual Appeal, Design Flow, and Energy. So, ladies and gentlemen, without further ado, please welcome our first speaker, Professor Tima Drinotsi. She will be delivering a speech with the title, How to Best Address Post-COVID Challenges, a Legal Perspective. Professor Drinotsi, the screen is yours.
Thank you. Yes, okay, now I can see myself. And Professor Dr. Rockman, Rector Universitas Negeri Semarang, Dr. Rodiah, Dean of the Faculty of Law, Professor Dr. Mahfud, Dr. Irawati, Organizing Committee of the 4th International Conference on Indonesian Legal Studies and Masters of Ceremonies. Thank you for this invitation and this nice introduction. Fellow speakers and participants, nice to meet you all, and I'm truly honored to be here and exchange thoughts with you today on this very important topic, the re-establishment of law during this magnificent Congress. Thank you for the fascinating videos we watched together about your university. And I would like to congratulate on these series of conferences and today's event. And I wish you all further successes and prosperity. My name is Tima Drinotsi, and I will talk about how to best address post-COVID challenges, legal perspective. I must have misunderstood something because my speech will be 20 minutes. So I'm sorry if it would exceed the allocated time frame, but I would like to really express my views on these legal perspective. And I hope that I can share my screen now and start the presentation. May I ask if I'm sharing my screen? Yes, I guess that I'm sharing my screen now, and then you can see the first slide. So let me begin. As we know, over the last more than 1 year, the pandemic has profoundly changed our world, and these challenges are far from over. the COVID-19 pandemic took its toll on the economy, employment, mental health, severely influenced the possibilities and rights of children, teenagers, and young adults, just to mention some examples. Post-COVID lawmaking needs to address these challenges in a normal time manner, using normal time lawmaking practices. This presentation will discuss the re-establishment of law after the COVID-19 emergency by focusing on two issues. The first is about how the restoration of normality can be done. The second issue is about how to ensure that the new laws best address the challenges we face in the post-COVID period. For achieving this goal, we must take a retrospective perspective. As for how to return to normality, we have to establish where we want to return from, because our point of departure will determine the path we could take. For this, we should pay attention to the distortions in the division of power and the role of parliaments. As for the second issue on the best possible legislative activity to address post-COVID challenges, we could remind ourselves of the existing tools we applied or failed to apply in the pre-COVID era to assure quality in legislation. We can think about ex-ante regulatory impact assessment, ex-post evaluation of laws, and involvement and consultation. So this is about point of departure, distortions in the division of power and the role of parliaments. An emergency has always been viewed as a threat to the constitutional system, being able to transform it into something unrecognizable. The COVID-19 pandemic proved this fear to be true, even though, as Itai Barsimantov and Elena Grillo explained in the summer of 2020, the majority of parliaments, after the first shock and some wrong answers, such as shutting down parliaments, started to live up with the challenges of social distancing rules procedurally, and that of the pandemic, content-wise, and in terms of oversight. Nevertheless, after the 15 months of the first declaration of the emergencies, there are more experiences. Based on these, the actual diversions the emergency caused on the normal operation of state affairs can be collected into 6 interrelated and sometimes overlapping groups. This is what you can see in this slide. I will also bring some examples. Being Hungarian, whose research interest in the last 6 years revolved around the illiberal transformation of the Hungarian and Polish constitutional systems, I'm using mainly Hungarian and Polish examples, but I will mention other jurisdictions as well. Concerning the division of power, we can observe some degree of gradualness, abusive practice, attempts to abuse power, and shift in the division of power. First, the 2 best examples are Hungary and Poland. Past events are known, so I'm just mentioning the most recent Hungarian one. The government extended the 3rd constitutional emergency amid the vaccination and opening up strategy. There is now a legal basis that can be used to prevent national and local referenda about highly controversial governmental investments, such as the Budapest branch of the Fudan University, which is a Chinese public university. As for the attempts, here comes a well-known Polish example. In spring 2020, the government disproportionately limited the freedom of assembly and intended to manipulate the presidential election. However, the presidential election was held just a little bit later than originally planned, based on new rules more in line with international standards than the first submitted draft laws. Regardless of the rules on freedom of assembly, people could protest for weeks in Poland against the abortion decision of the Constitutional Tribunal of October 2020, not without disturbance though, by the police. The last category, which you can see here, overlaps with the marginalization of parliaments in terms of participation of MPs in proper oversight, as authors from the UK argue. We could also see the metamorphose of medical scientific experts from decision-making input into decision maker in Australia, as Eric Lindholz observed. While extensive legislative and executive decision-making authority has been delegated to experts in Australia, some newly hired experts have made strategic decisions on pandemic-related roles in Brazil, while completely disregarding scientific expertise on what medicine should or should not be applied for COVID-19, for the virus, actually. As we could have seen, during emergencies, parliaments in some places have been marginalized. Elsewhere, still during the emergency, their role has been left formally intact, even increased, and used to make systemic changes due to the illiberalization of their countries and not because of the nature of the emergency. As said, the British House of Commons has suffered a severe marginalization in its oversight and legislative function. MPs did not have enough time and possibility to express their views on laws and regulations, neither could they entirely benefit from the possibilities of virtual participation. From a constitutional law perspective, the oversight function of the Hungarian parliament was disregarded in the first Coronavirus Act, which introduced the first constitutional emergency in March 2020. Nevertheless, the government had a constitutional majority in the parliament. Thus, from a perspective of the power structure and the operation of the constitutional system in Hungary, taking away the possibility of oversight did not matter. Ever since 2010, a genuine parliamentary oversight has not been expected in the Hungarian illiberal constitutionalism. The emergency, as I said, also increased or left intact the importance of parliaments in states where we could observe the systemic abuse or misuse of emergency power to achieve certain political agenda during the emergency, but beyond managing the pandemic. The prominent example are here again, Hungary and Poland. Their normal time measures might have even been more harmful to democracy, the rule of law, and human rights protection. Consider the Hungarian parliament's decision not to ratify the Istanbul Convention on preventing and combating violence against women and domestic violence. While in Poland, the parliament has discussed the withdrawal from this convention. Even a constitutional amendment was passed in Hungary in November 2020 during the second constitutional emergency, which continued to disrespect, the constitutional amendment continued to disrespect the rights of LGBTQI people. Lastly, some words about the diminishing quality of laws. Emergency measures have been adopted without observing the elements of democratic lawmaking process, such as regulatory impact assessment, consultation, deliberation. Priority has been the fast response to the challenges of the pandemic that was, for instance, in Poland, coupled with extensive use of omnibus legislation, as Agnieszka Bienka-Cala explains. Urgency resulted in poorly prepared emergency decrees. In Hungary, the Line Ministry did not consider the possible increase of domestic violence when adopting lockdown rules. It took the ministry more than a month to rectify this failure by amending the relevant decree. Let us see now the second issue, which was about ensuring that the new laws best address the challenges we face in the post-COVID period. Even though several best practices originate from many countries, the OECD report established in 2015 that ex post evaluation has remained relatively sidelined compared to ex ante regulatory impact assessment, and systemic ex post evaluations are less common. It also urged for a more strategic use of ex ante RIAs. The regulatory background for conducting regulatory impact assessments is usually in place in most Central and Eastern European states. Their actual use, however, is another issue. For instance, at the beginning of the 2010s, ex post assessments have been introduced in this region. They were even planned, but except for Poland, were not actually conducted. After 2015, with the remodeling of the Polish constitutional system, these assessments have become less common. In Hungary, in 2020 and 2021, through a series of legislation, healthcare professionals' service relationship was reformed, and almost all universities were privatized without any regulatory impact assessments and consultation. While there seems to be a demand and practice for better inclusion of, for instance, marginalized groups elsewhere, in Hungary, not even the experts or those directly affected by a new law are consulted. The latest example is the COVID-19 related opening up on the 7th of April 2021. It did not have epidemiological reasons and experts did not advise it. Experts claimed that the mass immunization of a country with 9 million inhabitants could not be achieved after the first vaccination of 2.5 million people at that time, obviously around the beginning of April. Now we have arrived to the central questions of this presentation. How can we reestablish a functioning normal time legal system with its more balanced division of power, lawmaking activities, and oversight? And the second was, how can we assure that the new laws best address the challenges we face in the post-COVID period? There is no one-fit-all solution. The solution is context and jurisdiction related, but there are some fundamental considerations on which maybe most of us could agree. The entire constitutional structure needs to be retransformed or re-established to or towards normality. Only if it is done can we, with good conscience, start re-establish the lawmaking process to produce the best laws possible to tackle the pandemic's various consequences. In some cases, this retransformation or re-establishment is more feasible and might be easier than in others. Where the executive abused or tried to abuse its emergency powers for purely political purposes, retransformation is not only the matter of returning to normality from emergency. The democracy and constitutionalism, for instance, in Hungary and Poland, are in a much worse shape now than they were pre-COVID, and not only because of the toll the pandemic-related emergency took on the constitutional system. If healthier constitutional democracies want to leave the COVID-19 pandemic era behind, they should first restore the deliberative and oversight roles of parliaments. It could then be followed by identifying and rectifying the harmful emergency decisions by the tools of political and legal responsibility and adopting amendments to laws or repealing them. For that, immense ex post evaluation of laws or extensive post-legislative scrutiny is needed. Therefore, these countries could look at their pre-COVID-19 rules and practices of the lawmaking process, assess them, compare them with the requirements of democratic lawmaking and existing best practices, and make changes if needed. As for adopting new laws for the post-COVID era, they need to do the same with the other aspects of the lawmaking process, such as ex-ante regulatory impact assessment and consultation. States need to take the importance of the cyclic nature of lawmaking, the interconnectedness of ex-ante and ex-post evaluation of laws, and consultation seriously. Regulatory impact assessment is both a tool and a process designed to help inform political decision makers on whether and how to regulate to achieve public policy goals. Conducting ex-ante regulatory impact assessment is primarily a task of the governments, which governments with a possible exception for regulatory impact assessment dealing with important amendments made during the parliamentary process. Ex-post evaluation of laws provides feedbacks into the regulatory process. RIA includes cost assessments and the measurement of many other impacts as well, such as social, environmental, anti-corruption, the rule of law, human rights, and an examination of benefits and other consequences. Consultations need to be organized in the pre-parliamentary phase during policymaking as early as possible on each policy option. It could also be linked to the ex-post evaluation. They need to be planned, coordinated, and conducted in a timely manner. In the parliamentary phase, the potential of consultation increases when the government is reluctant to organize meaningful consultation or when the issue is controversial. Attention needs to be given certain newer developments in the understanding of what a meaningful consultation means. Meaningful consultation facilitates inclusive participation, invites as many views as possible, counterbalances existing power relations, and uses jargon-free language and child, youth-friendly, age-appropriate approach in an accessible space, be it off or online. To this end, a meaningful consultation also requires initial research on consultees and stakeholders. Yes, it is a resource and time-consuming process, one that should not be overlooked. Thus, political and professional efforts need to be made to conduct assessments and consultations. Otherwise, the quality of the post-COVID laws cannot be achieved. Quality in legislation means legislative process and the content of the adopted legislative measure promote quality. The legislative process may be of quality if the entire legislative process or policy cycle is adequately regulated and these rules are properly implemented. The content of a law is of quality if it can reach the constitutional, legitimate, legal, and necessary legislative aim. It follows that the quality in the content of laws is dependent on the quality of the legislative process. Allow me here a final remark. If we want to ensure that the new laws best address the challenges that we are facing in post-COVID period, we need to reassess the shortcomings of our legislative system and be inspired by best practices and recommendations of the international community. It will be only possible if we could first re-establish a normal time legal system with its balanced division of power and proper functioning of the legislative bodies. Thank you very much for your attention. I'm looking forward to your comments and questions.
Speech. I'm sorry. So I know some important matters that you've already mentioned in your speech. Is that it needs to reassess the shortcoming of the legislative system and be inspired to reestablish a normal a legal system, and the inspiration we must get from like the international community. So hopefully I can draw some, it is correct from what you have talked for us today. So thank you so much. So now we have Professor Martita for our second speaker today. So Professor Martita, the screen is yours.
Good morning. Assalamualaikum warahmatullahi wabarakatuh. The Honorable Keynote Speaker, Professor Dr. Mahfud MD, the Coordinating Minister for Political, Legal, and Security Affairs of the Republic of Indonesia. The Honorable Rector of Universitas Negeri Semarang, Professor Dr. Fatur Rahman M.Hum. The Honorable Vice Rector for the Academic Affairs, Professor Dr. Zainuri. For the General Affairs and Finance, Professor Dr. S. Martono. For Student Affairs, Dr. Abdurrahman. And for Planning and Corporation Affairs, Dr. Hendy Pratama. The Honorable Invited Speaker, Professor Mary Science Bruri, Professor Ceko Bahruisen, Dr. Siti Hafsah Idris, and Professor Dr. Tema Drinorsi. The Honorable Invited Guest, the Honorable Dean of the Law Faculty, Dr. Rodiah, and the Vice Dean of the Law Faculty for the General and Financial Affairs, Dr. Ali Mazhar, for the Student Affairs, Tri Sulistiono, Master of Law, and the Coordinator of Master of Law Program, Dr. Indah Sri Utari. The Honorable Speaker and participant of the fourth International Conference on Indonesia Legal Study, the Honorable Academic and Academic Staff of the Law Faculty. Thank you for having me. My name is Martita and I am going to be speaking to you about the role of constitutional courts in the achieving socio-equilibrium in Indonesia. The begin with during COVID-19, the Indonesian Constitutional Court has been implementing virtual courts. Only judges who attend the court physically, while the parties might attend virtually. In the addition to that, parties could submit application online to the Digital Corner or other electronic media. Furthermore, on the one of the organs of the constitutional courts in Indonesia, the decision of the Constitutional Court have always maintained the balance between the constitutional and the various interests in accordance with substantive justice. Lex semper debit remedium, the law will always bring improvement. Law was created by government for not to be toxic for society. Judicial review in Indonesia constitutional courts. Key point for many judicial review cases in constitutional courts was society. The society in already law literate and constitutionally literate, especially in relation to judicial review. 2. Lawmaker. Government and lawmakers still serious in making the law. 2. Constitutional Court. The Constitutional Court is a judicial institution that is hardly trusted by the public to resolve cases concerning constitutional rights that are violated by the enactment for socio-equilibrium. Realizing the harmony of social interaction in heterogeneous or multi-ethnic society order. Law enforcement in Indonesia from progressive law to response law. Progressive law view law as an institution that aims to lead humans to a just, prosperous life and make humans happy. First, law is for man, not man is for law. Second, law is not as absolute and final institution because law is always in the process of becoming. Public participation in lawmaking is expected to become an organ of social control and a balancing force between the interests of the government and society. In a situation where responsive law exists, the opportunity to participate in lawmaking is more open. In this sense, law become in kind of political forum and legal participant in contain a political dimension. Responsive law is law that is ready to adopt a new paradigm and left the old one. This means that the law is not longer seen as an independent entity, but it must be able to interact with other entities with the main goal to adopt the interests that exist in society. Substantive justice become fixed price in the constitutional court. Selection justice substantive by court constitution background profusely demands order the constitutional court give the decision that give the solution law on uncertainty by professions that multiple interpretation to something principle or the rules law on moment occur empties law. Sub-court constitution for justice procedural become justice substantive not or will. Courts just constitution for expand competence that own courts constitution will but solely only for enforce constitutional courts as the guardian of the constitution. This is consequent from that the court's constitution for ensure that selection court's constitution, the right, the decision court's constitution must with weigh the right, honest, and while so that public and party all support continue attitude that taken by courts. Constitution not precisely brought every decision court's constitution that considers the fight from what that has been said. Court's constitution in run authority, especially in case testing constitution on in the principle not can only lean back on spirit, legality, formal, the rules written, but too must able and presenting score justice, substantive for public, social justice. We do not want to be bound by a law that does not provide legal resource, because if it does not provide legal resource, it will not be of benefit, where the constitution anywhere always rests on the thing justice, certainty and benefit. To achieve it is necessary to lead, to have clarity and firmness in the just attitude in making decision. Constitutional justice must be fair and able to elaborate legal consideration with fact in the trail in a decision, so that people at all level can easily understand and feel the benefit of the decision. Law in constitutional courts make a decision that is regulating as an innovation for the renewal in accordance with the chain of justice that exists in society. This is what is called judicial activism, Professor Dr. Laisa Marzuki. Law in the form of statutory regulation is incomplete and will never be complete, meaning that here the just make law if indeed written law does not exist or is unclear. Ahmad Fadil Sumati. The basis for the ruling of the Constitutional Court, which is regulating, can be seen in Article 45, Paragraph 1 of the Constitutional Court law, which state that the Constitutional Court decides case based on evidence and belief, material truth, justice, benefit, and urgent situation that must be resolved. Muhammad Alim. The basis for the Constitutional Court to make decisions that are regulative in nature is the element of urgency, the element of substantial justice, and the element of benefit. Maria Farida Indrati. Constitutional courts in achieving social equilibrium. The chaos of law, order, and the legal gap can be restored not necessarily by making new law, because the formation of law by legislator should also look at the legal awareness of the society and the whether it can create a new pattern in society. In addition, the formation of law must be aimed at relation, social balance, socio equilibrium, so that law can accommodate all group and does not tend to be discriminatory in favor on one party. The guardian of the democracy. 2, the guardian of the Constitution. 3, the protector of the citizen constitutional rights. 4, the protector of human rights. 5, the final interpreter of the Constitution. And 6, socio-equilibrium. Verdict number 97, 2016. The emptying of population death element on religion has also had an impact on the fulfillment or other rights as such as marriage and population service. Those believers of faith do not get the assurance and equality before the law and government as stained by other citations. At the same time, this is a loss of the constitutional rights of citizens that shall not occur. Verdict number 102, 2009. The Constitutional Court issued a decision by making provision that were very technical in nature, which basically allowed citizens to exercise their rights to vote by showing the ID card, family card, or passport at the time of voting. The Constitutional Court also made specific provisions that must be fulfilled by protesting voters who have not been registered, among others. This prospective voter can only exercise their voting rights and the TPS on or before the closing of the voting process. The verdict number 46 and 2010. In this ruling, the Constitutional Court made a legal breakthrough by stating that unmarried children still have a civil relationship, not only with their mother, but also with their biological father, The legal resource behind this legal breakthrough are to emphasize that children outside or married have the right to legal protection. The Constitutional Court has legal consideration that accorded the need to provide protection and just legal sentencing for the status of the child who is born and the right that exists to it, including for children born often thought the legality of the marriage is still dispute married blood father. Verdict number 22, 2017. The Constitutional Court overturned the minimum age limit for women to marry. The Constitutional Court also stated that the provision of Article 7, Paragraph 1 of Quo Law are still in effect until changes are made in accordance with the grace period as stipulated in the decision, which is a maximum of the year order the verdict is pronounced. According to the Constitutional Court, the provision of our article are discriminatory and unconstitutional because they distinguish the minimum age for marriage between men and women, which cause women to experience discriminatory action in fulfilling their constitutional rights. Conclusion. The constitutional is here to break the deadlock from the dire condition that are happening in society. Decisions that are positive legislature as well as decisions that are usually initial, namely conditional decisions such as conditionally constitution and conditionally unconstitutional emphasis substantive justice rather than procedural justice. So this decision in the Constitutional Court is trying to maintain the supremacy of the Constitution as the highest law and to provide protection for the constitutional rights of the citizen. Constitutional Court's decision always maintain a balance between the constitutional and various interests so that these decisions are not only legally correct but will also be fair by citizens. In this context, it is appropriate if the Constitutional Court can play its role as balance to the social order of society, socio-equilibrium. I would like to end my speech by saying this word. Having an advanced technology may help us going through COVID-19 pandemic. Nevertheless, having a legal system that benefits society in an advance to save humanity. Thank you.
Thank you so much, Professor Martita, for a very interesting talk. So before we go on to our third speaker, I would like to inform you that if you have any question, you could raise it and we will give the screen to you. Because of a technical matter, we could not open the chat box for you. So Professor Martita, if I could take just a little bit note from your speech is that the role of Constitutional Court in Indonesia not only as procedural justice, but also as substantive justice server. So we proceed to our third speaker, Professor Sainsbury. Hello, Professor Sainsbury.
Hello.
Hello, yeah, Professor Sainsbury. So you will talk about the small enterprises in Australia, if I'm not mistaken, and the regulation, yeah, small businesses. And yeah, justice in Australia. So Professor Sainsbury, the screen is yours.
Selamat pagi and hello from Canberra, Australia.
Selamat pagi, hello.
So I'd like to offer my thanks to the Universitas Negeri Semarang, Rector Professor Dr. Fadhil Rahman, and the Dean of Law, Professor Dr. Rodia, for the invitation to speak at this conference. Also, my thanks to the organising committee and in particular to the moderator today, my PhD student, Irawati. And thank you very much to the previous guest speakers, Professor Tamia and Professor Martita. I think there's a lot for us to be thinking about. And in particular, it's gotten me thinking about the importance of the rule of law during emergency situations such as we are facing now, and the importance of protecting the vulnerable in our societies. So just an overview of what I'd like to talk to you about today. I want to talk about small business and the legal environment in Australia, and in particular how COVID-19 has impacted, touch a little bit on the legal response to supporting small business, but really focusing on the difficulties that small businesses face in accessing to justice more generally. So I'll start by talking about the nature of small business in Australia, the significance of small business to the Australian economy, which I understand from Irawati's work, it's also a very important part of the Indonesian economy. So it's a really important thing to be thinking about and to supporting and fostering small business operators. However, small business owners are facing a really complex commercial and legal environment. And this is in part due to COVID-19, but not entirely. So I think there's going to be ongoing things to be thinking about post the pandemic. So small businesses and the people working in them and the small business owners are particularly vulnerable. And the inability to access effective legal services is quite significant, not just for the small businesses themselves, but also more broadly for society. So I want to talk about some of the different ways that we might respond, and in particular talk about what we're doing here at the University of Canberra to play a very small part in addressing some of these issues, and to get people thinking about our role as educators and what we can do with our students to be really making them aware of some of these problems, but giving them the skills to play a role in solving them. So these are just some of the ways that small businesses are recognised in Australian law. Now, the Australian legal system is complicated because it's a federal system. So we have laws that impact on small business, both at Commonwealth and state and territory level. So it's depending on the area of law as to who is making the laws with respect to it. And the definitions differ depending on the purpose of the law. So I've just put up a few examples there. So for the purposes of the corporations law, then again, even within that legal sphere, the definitions can vary. So I think this is the first part of the complexity for small business owners, is just even first identifying whether you are a small business for a particular purpose. So for corporations law, then the tests used are both based on revenue and on the number of people employed. Whereas if we look at the taxation laws, you can see there that the test is obviously more appropriately derived from the revenue of the small business entity. And for Fair Work, which is the laws that regulate our employment conditions, there it's based on the number of employees. And you can see there the distinction that I think you also have in your Indonesian legal system. There's sort of 3 tiers of small business, starting from what we call non-employing businesses, so your sole proprietors, micro businesses, which may employ between 1 and 4 people, and then other small businesses for the purposes of employment law, between 5 and 19 employees. So just looking now at some of the economic contributions that small business makes to the Australian economy. So some of the figures you can see there. So it's around 35% of our gross domestic product, 44% of employment in the workforce. Out of all employing businesses, 93.8 are small businesses. And within that category, then 76.2% meet that definition of micro business. So for people that are interested, I've put up some links there to some further statistics and information on the nature of small business. You can see that it is really quite significant, both to the economy and also to the workforce in Australia. And it's also the nature of the contribution that small business makes that I think enhances its significance. So you can see there that most of our innovation is happening in that small business area in Australia. And most of our job growth also is coming from that section of the economy. So from there, I think you can see that it's extremely important to us to be supporting and fostering small business, particularly during this time of the pandemic. Just wanted to talk about some of the different aspects of the vulnerability of small business that we should be addressing. So firstly, economic. The statistics show that small business owners are usually earning incomes well below the Australian average wage. Average annual wages for employees of small businesses are consistently less than half the wage of an employee of a larger business. In addition to that, then there's also the flow of business income, which can be impacted by things such as late payment of invoices and difficulties in accessing finance. So these really impact on the survival rates of small business. And again, the statistics show that the smaller the business, the less likely that it is to survive. The complexity of the law, and I've already shown you the differing definitions of small business and talked a bit about our federal system, which means that laws regulating different areas of operation could either come from the Commonwealth or state or territory level. Where it is state-based, then it may be different across Australia, depending on where a small business is operating. So if they're operating across borders, and again, there's a lot to become aware of to properly inform themselves about the laws that apply to their particular situation. And I think that's a significant barrier for small business owners to navigate the legal system. Lack of expert knowledge. This is due to the small scale of small business. They're going to be limited in scope. It makes it less likely that there's going to be access to the diverse range of business and legal expertise that you need to operate successfully. Also, within Australia, small business is more likely to be located in regional areas. So that's again going to make access to specialist knowledge and services increasingly difficult. Australia is a very geographically spread out continent, and some of the regional areas in which small business will be operating will be hundreds of kilometres away from a main commercial hub. So this vulnerability has really been significantly enhanced as a result of the COVID-19 pandemic and its impact on the business sector. So some of the impacts on small business have included temporary closures, which are still ongoing at the moment. Melbourne, our second largest capital city, is under lockdown. So the small businesses there would have to close for at least 2 weeks. So that's going to lead to loss of income for the business owner, potential staff layoffs, and then also the impact on the broader commercial environment in which small businesses are operating. So there'll be things like supply chain disruptions, disruptions to contracts, and just a general environment of ongoing uncertainty and unpredictability. In addition to that, you've got complex workplace health and safety laws that the business owner needs to be aware of and complying with, as well as the public health measures that are constantly changing. So for businesses that are already financially fragile, it's often meant that the business itself becomes unsustainable. The impact of COVID-19 is going to have a differential effect across different sectors of business. So the areas that have been most severely affected will be in tourism and hospitality, retail, arts and entertainment. So in contrast to that, small businesses operating in areas such as finance and professional services will have experienced less disruption. So I've put up some statistics there. Our Bureau of Statistics have been measuring the impact of COVID-19 on business. So you can see from those figures that it's the larger businesses where income has been more likely to have increased and less likely to have decreased. Whereas as the business levels get smaller, then there's less likely to have been an increase and more likely to have been a decrease in revenue. And I think this is going to be a trend for quite some time yet. So while business in general is impacted, it is really more significant in that small business area. The government response to the pandemic has made the legal environment a lot more complex for the business sector in Australia. And I've just put up 2 examples there of some of the government responses that will have impacted on business owners. So the JobKeeper payments were designed so that businesses could keep employing people during lockdowns. This support mechanism has now finished. There were some eligibility criteria that you needed to demonstrate a particular percentage drop in your turnover. And that percentage depended on your general annual turnover. So for most businesses, you needed to demonstrate a 30% drop in revenue. But as I've said, the JobKeeper payments have now ceased, even though we are still seeing reactions to COVID-19 from state and Commonwealth governments in the form of lockdowns and border closures. There were also some provisions put in place for commercial leases. This was based on a Commonwealth government mandatory code of conduct, which required the landlord to negotiate in good faith with their commercial business tenants. And if the commercial business tenant was impacted by COVID, and the main way to demonstrate that was by showing they were eligible for JobKeeper, so that they had that 30% drop in revenue, then the landlord was obliged to negotiate for reductions in rent. And the guiding principle was that any drop in revenue should be split between the landlord and the tenant, and that part of that loss of rent could be deferred and part of it had to just be written off by the landlord. Now, this was quite an uncertain provision. It was written as a mandatory code of conduct, but it talked about vague concepts such as good faith negotiation. So it created a lot of uncertainty both for landlords and commercial tenants. And there was a lot of bad faith in the community with landlords not really doing the right thing by their tenants. There's still some transitional provisions in relation to those mechanisms in place until the end of this month. So I wanted to just have a look now at some of the support that is available to small businesses in Australia. And again, this is complicated by our federal system. So some things are provided at Commonwealth level and some are state-based and will differ depending on where you are in Australia. So legal aid is really very, very limited for civil matters. Generally, legal aid eligibility is determined by both a means test and a merit test. So for civil matters, it's quite restricted to employment or situations where the applicant may lose their home. And there's very strict means tests that apply. So very few small business owners will get a legal aid grant of assistance to help them. Some of the private law firms will take on pro bono work for small businesses, and some of the law societies also offer pro bono support, but often this is just limited to initial consultations rather than ongoing legal representation. So it can be quite hard for business owners to navigate and to work out where they can go for assistance. So I think this creates a gap in access to legal services and some unmet legal need. And I've just put up a quote there from Professor Simon Rice, where he's emphasising that often we don't think of small businesses as requiring access to justice. When you think about access to justice, you might think about it operating in areas such as criminal law or family law. But I think both because of the importance of small business and their vulnerability, it is an area where we could be thinking more broadly about what access to justice really means. That if someone is going to lose their livelihood and their earning capacity, I think that is really an access to justice consideration. So in addition to legal services, there are a number of other places that small business owners can go to look for information. And I've just put up some there. But again, I do think it's hard for business owners, firstly, to identify the type of assistance that they need, and then where to go to get that help. So in thinking about what we could be doing better, I think an effective access to justice system for small business owners, it would be low cost. I think that it is important to get business owners to think about legal services and professional services in general as a business need and something that they should be funding to some extent. But usually they're really priced out of the market in taking forward and satisfactorily resolving legal disputes. It should be easy to understand and accessible. And there should be mechanisms to avoid something that is too adversarial. So an emphasis on effective dispute resolution, alternative dispute resolution mechanisms, particularly where you've got two parties that need to maintain a business relationship, then usually an adversarial solution is not going to be the right one. The other thing I think it's important to think about with small businesses is that often their needs are not just legal, that if we could be providing some multidisciplinary support that gave them some financial assistance alongside the legal, rather than them having to go through two separate channels to get that, if we could bring it together and look at the overlaps, then I think that would be helpful. The other thing with legal issues and small business is that these statistics also show a tendency for what we call a clustering of legal problems. Once a small business starts to face legal issues with respect to their business, it has a lot of flow-on effects for the business owner and their family and their employees. So often there will be business issues that might overlap with family law issues, for example, where it's a family-run business. Cash flow problems may lead to difficulties in meeting taxation obligations. And beyond just the legal problems, it's also been shown that there's a broader impact of legal problems that extend to stress-related illnesses, relationship breakdowns, and financial strain. So just to finish, I wanted to talk about what we're doing at the University of Canberra and how it's important as legal educators to be raising the awareness of both our law and our business students that some of these broader issues around access to justice. So in the law school here, we run a small business legal advice clinic where we offer initial free legal advice to businesses that have a legal issue. We work with volunteer solicitors from the Canberra region, and students enrol in the course, so they get credit towards their law degree, and they'll come in and assist the volunteer solicitors in the clinic. So we know that the best way to educate students in any discipline, but particularly in law, is by showing them how the law works in practice. And this is a really good mechanism to do that, to help them develop their professional skills, but to also make them aware right from the start of their legal studies that being a lawyer involves obligations to society, and they need to start thinking about pro bono work right from the beginning of their studies. So thank you very much for listening to me, and I'm looking forward to the discussion and questions.
Thank you, Professor Sainsbury, for your noteworthy speech. So Professor Sainsbury spoke to us about how the important actually for the government and legal system, and also legal professionals to help small businesses which help justice because of the pandemic. So I guess that's one of the noteworthy from Professor Sainsbury. So I welcome for the authors and participants to raise your questions. So you could raise your hands at the screen for your question. So while waiting for audience to raise question, I think it's honorable for me to ask question first, if I'm allowed. So Professor Tima Drinotsi. Hello, Professor. Hello, Professor Drinotsi.
Hello, I'm here. Yes, I can hear you.
Yeah, thank you, Professor. So yeah, we are still waiting for the questions from audience. But if I'm allowed, I would like to ask you a question. So it's just like, yeah. So the question is that I understand that the effects of this pandemic are multidimensional, while the government must establish regulation as soon as possible. Like at the moment, actually only like more than a year, but the government, like in Hungary, must provide a regulation that benefit the people in Hungary. So, Professor, could you please explain more how the parliament in Hungary handle the legislation process up until now? And also, could you please give us insight about how successful the regulations in helping the people of the country so far? So, if I'm not mistaken, you've mentioned about the vaccination policy. So probably you could give us more on that. So yeah. So would you like to respond now, or is it okay if I go on to another speaker first to ask a question?
Yeah, I think that you just ask questions, and when all the questions are asked, we can answer.
So yeah, so I will go to Professor Martita. So, yeah, Professor Martita. Yeah. So I have a question. In your speech, you said that the Constitutional Court is actually an institution whose authority is negative legislature. However, so far, in Indonesia, Constitutional Court has made many positive legislative decisions. So it is, I think, interesting to know more about under what conditions actually can the Constitutional Court make a decision that is positive legislator.
Okay.
So yeah, and Professor Sainsbury, if I'm allowed, I would like to ask you a question. So you mentioned about the vulnerability of small businesses in Australia. So probably it is interesting or noteworthy for us to know what are the measurements in Australia for the vulnerability of small businesses. And then I think it is also interesting to know, is there any priority given from the government for probably any sector to be helped, like for in giving commercial lease? Is there any priority? Yeah, that's for now. So thank you so much. Yeah, we are still waiting questions from the audience.
Excuse me.
Okay, we are still waiting. So I guess the time is, I will give to Professor Drinotsi to respond the questions. Professor Drinotsi, the time is yours.
Thank you, Irawati, for these questions. I think that these are very important ones, because then now I can talk a little bit more about Hungary, because in my presentation I tried to give a little bit of overview. And so you asked about how the rules which have been adopted in Hungary could have been beneficial to the people, or to the Hungarians, and then the role of the Hungarian parliament. So I think that we have to, it's a very complex question. So I think I will just focus on a couple of issues. The first is that I think everybody knows that there is this issue of emergency powers and governance by emergency decrees issued by the government in Hungary is very controversial. And also the first introduction of the first constitutional emergency is very controversial because of constitutional concerns. Basically, that in the first Coronavirus Act, the oversight function of the parliament was completely switched off. So the constitutional requirement of the effect in time of the decrees were not observed, meaning that the parliament couldn't review the emergency decrees after described period of time, which was which is 15 days. So, but not really regardless, but a little bit regardless of these controversies, in the very beginning of the pandemic, we can say that there was a must or a very much need for issuing emergency decrees, because no one knew, not only in Hungary, but I guess that nowhere, what to do exactly, how to address the virus, which affected many people and also businesses and our daily life. So this would be maybe the beneficial effect. On the other hand, I also think that after a while, after the first emergency, things should have been reconsidered, and the Hungarian government and parliament did not reconsider these issues. And also what is very concerning is that why the increasing power of the executive is justified by the fact of the pandemic, of the emergency. And on the other hand, the parliament operates like in normal times. And I brought some examples with international conventions. And I also mentioned that during the third constitutional emergency, which is justified by the virus, during which the executive has extremely powerful competence and authority to govern the country, the parliament could act as a constitution amending power. So isn't it a little bit controversial? So that is what I tried to explain or rather mention in the presentation. So while we give a lot of power to the executive to govern us because of the pandemic, we still use the parliament to do normal, ordinary legislative activity. And so it is strange. Let us just say that. And benefit to the people, yes, the vaccination is going quite well. More and more people get vaccinated, of course. There are controversial issues concerning this as well. I mentioned that the introduction of this opening up strategy, the timing of that, and also I could mention the fact that in Hungary, vaccines are used which has or had not been approved by European authorities or authority of the European Union, for instance, which is causing or which will cause some troubles in the freedom of movement, for instance. It raises the questions whether some kind of vaccination cards, immunity cards issued by the Hungarian government will be or will not be accepted by other member states of the European Union or at all other states. And this can be traced back to the fact that the government usually just do things. So they just come up with an idea and they powerfully brings it into reality without even proper preparation or thinking through. For instance, now you get your immunity card after the first shot of the vaccine, and this card doesn't say that it was only the first shot. It doesn't say what kind of vaccine you received, but then it is issued and you have it, and then you think that now I'm immune, but you are not. And then it brings us to the other issue, and then that will be the last one I mentioned, is the information. How many information and what kind of information we get, or that they get there. I'm in Brazil now, but they get there in Hungary about the vaccination, the cards, the need, and possibilities. Yes, thank you.
Thank you, Professor Dynodzi, for your comprehensive answer. So, is it okay if I have another question, Professor? Because I'm very curious with what happened in Hungary. So you also talk about democracy, a key terminology in your speech. So what are the measurements that should be used to make sure that the regulations related to the COVID-19 pandemic, and particularly that are established in this time, will not violate the liberty of life, economy, and probably expressions for the people in Hungary? So, yeah.
Iravati, another excellent question. Thank you very much. We've been talking about the democratic decay or illiberalization of democracy when we are talking about Hungary. So this is a good question because I don't really have an answer, because I cannot really say that these measures can be like assessed from a substantive democratic perspective, because I don't believe that Hungary has a substantive constitutional democracy at this moment. But and yes, how we could measure, for instance, I think that one of the possibilities of this, and beyond my speech, because in my speech I said that ex post evaluation of laws should be made, and then you can have a look at the actual effect of the laws, and then you can think about, hey, what I wanted to achieve with this particular law, and now it is enough in effect in the last couple of, I don't know, months or a year, and now you can have a look at the actual effect, and then you can compare, and then you can have a conclusion about the effectiveness of the law. But my answer would be beyond this. So I think that one of the kind of measurements could be that you have a look at the case laws of the courts, and in our case it would be the cases the Constitutional Court decides concerning petitions on COVID regulations. And what is interesting is that we have a lot about that, and we have just a few cases before the Constitutional Court. And for instance, there was none petition challenging the constitutionality of the Coronavirus Act, which I mentioned, the first one, in terms of this oversight issue, so that it took the oversight possibility away from the parliament. So there was no petition challenging this. There was another petition challenging basically the freedom of speech during the pandemic, and then a Constitutional Court in this respect said, for instance, that the modification of the criminal code, which introduced a new crime, was constitutional. So basically, if you express a statement which is false, and with this statement you will be able to hinder the effective protection against the pandemic, then you commit crime. That was more or less the wording of the new criminal conduct. And the Constitutional Court said that there is no problem with this here, because everybody knows what false statement is, which is true. Everybody knows what protection and effective protection means, which is not true, because we haven't had this crime in our legal system, because we haven't had crime which you can commit only during a state of emergency. And this crime was particularly adopted to criminalize certain activities during the state of emergency. So the Constitutional Court basically said that it is constitutional, but it set a constitutional requirement. And at the end of the day, with this constitutional requirement, it seems to be impossible to commit the crime. But de jure, it is in the legal system. De jure, the court said that the government and the parliament acted in a constitutional manner and still modified the wording of that provision. And so now you cannot apply at all. So there are possibilities, even in neoliberal constitutionalism, which would allow to protect certain liberties and human rights. But there are other examples in which this protection by the Constitutional Court was not provided. There was a decree which said that during an emergency, the public authority has 45 days instead of 15 days to produce the public data which you are requesting based on your freedom of information. And so previously it was 15 days, and now based on this emergency decree, it was increased to 45 days. And then it could have been, postponed and things like that. So instead of 15, you have 45. And in this case, the Constitutional Court said that there is no issue here. It's fine, it's constitutional, and it set a constitutional requirement as well, saying that when the authority is considering whether it can issue the data or the public information or not, it has to then justify the decision why it can or cannot issue the data. So basically the Constitutional Court didn't add it too much to the issue. What is important is that in an emergency, the Constitutional Court said that it is justified that the population do not get proper information in a timely manner, which is not defending human rights at all. And yes, we can go on with the other examples, but as I said, we do not have much case law available right now to have this assessment. And a little bit, yeah, thank you.
Professor, if you would like to add some more, we would like to hear that. Please feel free.
Okay, then thank you. What I wanted to mention is that another possibility to measure this democracy, the presence of democracy in the lawmaking process is if the Constitutional Court actually do a so-called semi-procedural review of legislation. So it does not only have a look at the content, the constitutionality of a given provision, if it is dealing with actual review of a law, but also it has a look at the lawmaking process, the end of which that particular law appears in the legal system. And here comes what I mentioned. So, and what I heard in the other presentations, that it is important that the public is involved in the lawmaking process. And it is also important to have evidence-based legislation. And how you will have evidence-based legislation? That you collect data, you make assessments, and you work with numbers and measurements and assessments. And only if you do that and based on evidence, you can make your policy choice. Now, the idea here is the Constitutional Court should have a look at whether the government or the parliament or the MPs, whoever is preparing the laws or the amendments to laws. So the most important thing would be here that the Constitutional Court has a look at whether the consultation actually happened. There was a possibility to everybody who should have been invited to share their views, and whether the proponent of the law made the proper assessment. And here, the Constitutional Court would not question the policy choice which was made, but would be curious about whether these procedural elements have been there during the preparation process of the lawmaking process, in the pre-parliamentary phase of the lawmaking process. Now, this is done in other Supreme Court, Constitutional Court, and international courts, but not by the Hungarian Constitutional Court. Because for the Hungarian Constitutional Court, the lawmaking process starts only when the law is submitted to the parliament. So it completely disregards the pre-parliamentary phase of lawmaking, but everything is happening there, right? So, I mean, in our parliamentary system. So, yes, this was what I just wanted to tell you more. Thank you.
Thank you so much, Professor Drinotsi. Actually, we received many questions for you, Professor. But before that, we also received a question for Professor Sainsbury. So before we go on to Professor Martita to answer the question, I would like to This is a question for Professor Marie Sainsbury from Mrs. Dewi, from one of lecturers in our faculty. So her question is, Professor Sainsbury, in your opinion, how can small medium enterprises survive from the impact of COVID-19? As you know, in Indonesia, we not only have what is called small and medium enterprises, but we also have a micro enterprises. So those enterprises in Indonesia almost died because of the impact of COVID-19. Is the same condition with what happened in Australia? And then what policies has the Australian government issued to protect the micro or small medium enterprises in Australia during the COVID-19 period? And what are the model for protecting them, especially during the COVID-19 period? So Bu Dewi has about 4 questions actually. Yeah. So, and how about we hand the screen now to Professor Martita to answer the question.
Okay, thank you, Mrs. Irawati. Thank you. Thanks for good question and very attractive your question, and I'm happy. The Constitutional Court is an institution whose authority is negative legislature. However, so far the Indonesian Constitutional Court has made many positive legislature decisions. Under what condition can the Constitutional Court make a decision that is positive legislation? Okay, the Constitutional Court can make a positive legislature decision if one is there is a legal vacuum in the authority is not a law. 2, there is overlapping the rules, overlapping the rule. And 3, there is an urgent situation that can cause chaos in the government, because in Constitutional Court in Indonesia is function is one the guardian of the democracy, the guardian of the constitution, and the protector in the citizen constitutional rights, and the protector of human rights, the final interpreter of the constitution, and socio equilibrium. Thank you.
Professor Martita. So the question has come very quickly at the moment. So before Professor Marie Sainsbury responds to the question, Professor Sainsbury, I would like to raise questions from the audience first to Professor Drinotsi, if it's okay. So first of all, there are questions for Professor Drinotsi from Mr. Laga. Mr. Laga is one of the lecturers at our faculty. So, for Professor Drinotsi, emergency keep endlessly reminding us what we will have to go on observing the same directives when this is all over, and that social distancing, as it has been euphemistically termed, social distancing, will be society's new organizing principle. So he would like to know what is your opinion in regards to that. And then he also raised 7 other questions. So Pak Laga, probably I will just give to Professor Drinotsi 1 or 2 at the moment. The first one is, why is the state of exception unjustified? So from your opinion, Professor, if confinement seems to scientists the only way to contain the spread of the virus. And the second one is, are we perhaps the implementation of a permanent state of exception? So that's some questions from Mr. Laga. There are some more, but yeah. I will give the screen to Professor Sainsbury. Professor Sainsbury, please respond to the questions arise for you. Thank you so much, Prof.
Terima kasih, and thank you for some very good questions. So I'll start with Erawati's questions at the beginning. So she asked about whether the Australian government has put in place any measures to sort of alleviate that vulnerability of small business. I think not enough at the moment. There are some general provisions built into our laws that do sometimes treat small businesses differently, particularly where there's some regulatory requirements. So reporting requirements, for example, for the purposes of the corporations law and our tax laws. There's also some exceptions to some of our employment laws. So some of the unfair dismissal provisions won't apply to small businesses. Where I think there should be more measurements to account for vulnerability is in dispute resolution. So I think a very common scenario is you have a small business owner that has legal rights. Most commonly, there'll be a breach of a contract or they need to recover a debt. The laws are there to protect them, but they're just simply not able to navigate the legal system or afford to be able to pursue their rights. So I think we have some tribunals that are meant to make access to justice a bit more affordable and efficient. But I think an expansion of that service would be something that could really help small businesses just in enforcing their existing legal rights. Erawati, you also asked whether there's priority for any particular sector in these measurements. Sometimes there is in our tax system. So, for example, we have some tax concessions for primary producers. But in general, the government response to COVID has not been based on targeting any particular sector or even targeting small business. So I think naturally they'll be more likely to be eligible because of the revenue impact on small businesses. But the JobKeeper payments, for example, there were a lot of very large companies that were able to access JobKeeper. And there's been a lot of public outcry about the fact that very rich business owners have benefited from that system and are now, they're not showing any drop in revenue now. And there's been a lot of calls for them to have to pay it back, but it's just purely voluntary. So some have and a lot just won't do that. While you've got a lot of small businesses that are still suffering. So to the audience questions, the first question was around how do small SMEs survive in this current environment? I think the ones that have succeeded or look like they're going to succeed are ones that have been able to really adapt their business practices. So I think it is good to know that small businesses are responsible for most of the innovation that's happening in the economy. I think they'll continue to do that. It's the ones that are going to be able to innovate and adapt and come up with different methods of doing their business that are going to succeed. And this is really what we need to happen. possibly I think there could be a bit more support for a transition to different business practices, but it's the people that are really clinging to past ways of doing things that are not going to work in the current environment for the foreseeable future that are not going to succeed. And so I think the audience question was the next one was around policies for small business, which I think I've answered. Nothing specific at all. They're now putting out some incentives to stimulate the economy. So one example is some of the states and territories are offering vouchers to the public to go and spend their money in different businesses that are more likely to be small local businesses. And the government will match some of that spending. So you might get a $50 voucher to spend, but you need to go and spend at least that amount yourself as well. So there are some targeted stimulus packages. In terms of what I think would be a good model, I think it gets back to what I mentioned in response to an earlier question. It's around access to dispute resolution mechanisms. But I also think that we just need to acknowledge that in the small business sector, it is common for businesses to fail ordinarily. So we need to work out where to put investment and where not to. So we shouldn't be propping up businesses that are going to fail anyway. And we're really just prolonging that process. And failure shouldn't really be seen as a bad thing in a free market. So it's about supporting people, like having safety nets in place, but also not over-supporting so that we are encouraging that innovation and transformation that we need to see. So I think I might have answered all the questions, but please let me know if I've missed anything.
Professor Sainsbury. Yeah, thank you so much for your answers. Before we go on to Professor Dinozzi, there is an audience who would like to raise her questions directly. It's from Aulia. I believe her name is Aulia. Hi, Aulia. Aulia, are you there? So if you would like to ask question to, oh, sorry, Dr. Aulia. I'm so sorry, doctor. I thought that you're one of our students. So Dr. Aulia, thank you so much. So yeah, the screen is yours to ask to Professor Dinozzi, Dr. Aulia.
Okay, thank you very much for the time. I have one question addressed to Professor Dinozzi. Good morning, Professor. I am interested about your presentation talking about emergency power. So my questions are, first, what is the impact of emergency power to civil society? And the second, can the emergency power guarantee the legal and political stability in countries during pandemic COVID-19? And the third question, if the government using the emergency powers in long term, can it cause the abuse of power inside the government? I think that's all my question. Thank you, Professor.
Thank you, Dr. Aulia, for your questions. So, Professor Dinozzi, I believe that are many questions have been raised to you. So, yeah, the screen is yours, Professor Dinozzi.
Thank you very much. I got extremely fantastic questions, and I don't have all the answers. And what I would like to start with is Mr. Laga's question. What that was about whether social distancing is a new organizing principle of our society, and what is my opinion on that. I cannot give an answer. I can give only my personal opinion, which is I would be happy if, to a certain extent, social distancing would become a kind of organizing principle in the society, because it would mean that when I'm in the supermarket, I don't have to, feel the other person just all over me. But that is just a personal opinion. I don't know how societies would think about social distancing in the future. As for, I got the two other questions here. And one was, are we implementing a permanent state of exception? And I think that it relates to the question of Dr. Aulia. Thank you very much for your three questions as well, because now she asked about whether the implementation of a state of exception would result in an abuse of power, I think. And that was the question. And my answer is yes, I think that it could result in an abuse of power, not necessarily because leaders, political decision makers want to abuse the power, but because long-term emergency, long-term state of exceptions are not really why we have state of exceptions. So we have these kind of constitutional design to overcome a shock in the society, in the legal system, in a state or in the world, and then after we need to restore normality, return to normality. So I think that after a while, emergency or a state of exception cannot be justified because in the matter of time, like 1 year or 1.5 year, half a year, lawmakers or policymakers must have come up with solutions and tools, legal tools or other tools to combat or fight against, in this case, a pandemic. And I think that if I'm thinking about Hungary right now, I think that we are in a kind of permanent state of exception because it is like not really understandable for me how we can open up and how we can be proud of how many people we have vaccinated. Now it is much more than 2.5, which I mentioned in the presentation, because that was the data from the beginning of April. So how we can do that and be proud and open up and everything, and then at the same time just extend the third constitutional emergency until autumn this year with the amendment of the third coronavirus act. And that is dangerous, I think, and that is why that we can detect some abuse of power. And stability, this is also Dr. Aulia's question, was whether the emergency power can be used to promote stability during the pandemic. I think that if it is used wisely, then it could promote stability. That is why we have emergency situations. That is why we put them very carefully in the Central and Eastern European constitutions. Those are very detailed constitutions. They tell you under what circumstances, who can do what until when, and who can overview the activity. So you have everything there, which is the result of our history and historical experiences with non-democratic regimes. But then again, it is very difficult when you are in an emergency to balance, I think. And I think that this a COVID-19 period was a kind of hopefully a learning period, and then maybe experiences can be then used to better, I don't know, regulate emergencies or just learn from mistakes or from good experiences. How it impacted, again, Dr. Aulia, how the emergency power impacted the civil society. I can tell you that in Hungary, it is interesting because Hungary, the legal system right now is not really friendly towards civil society, right? So this is what we know. But still, when I mentioned in the presentation this issue with not considering gender mainstreaming in the regulation on the lockdown in the very first weeks of the pandemic last year, it was actually some NGOs who were really loud about that, the fact that it could really severely impact women and because of the domestic violence. And so they could have some impact here, at least what I read in the news. So they were loud, and whether they could actually have an impact on the ministry, that is, I don't know, right? But they could have a voice. Yes. So, but obviously, when you have social distancing rules and you are expect the society or civil society to organize itself, it's difficult a little bit. And so thank you very much for these questions, Dr. Aulia. I hope that I answered them. And then now going back to Mr. Laga, because now, if you allow me, maybe, because I believe that there are some students with us, so I cannot, behave as I'm not a professor. And so if I manage, now I'm putting in the chat provision of the Hungarian constitution, based on which the first emergency was introduced, and based on which all the other three was introduced. And now why I'm doing this? Because Mr. Laga said that why is the state of exception unjustified when experts say that social distancing, lockdown has to be done because otherwise you cannot contain the virus, or you cannot protect the life and health of the citizens. And so I think that here, because I couldn't explain it in a very detailed manner in the presentation, there is a misunderstanding. So I'm not saying this. What I said was, what I would like to say is that it was legally challenged. I mean, it was not legally challenged, but in the political, not in the political, but in the scholarly discourse, it was challenged, the introduction of this first constitutional emergency. Why? Because first, as I said, the oversight function of the parliament was not ensured. And if you have a look at in this chat, and you have a look at the paragraph 3, you can see that these emergency decrees which the government can issue and by which they can suspend the laws and everything. So it's completely they can completely disregard legal hierarchy. So you can see that these decrees can remain in force for only 15 days, okay? That is the constitutional rule. And what happened in the Coronavirus Act was that it did not contain this 15 days rule, but it said that by this Coronavirus Act, the parliament accepts or approves all the previously issued decrees, because obviously decrees have been issued since the very beginning of the crisis, or the introduction of this emergency, and later on the parliament adopted the act. Now, in this act, the provision was this: the parliament approves all the already issued emergency decrees and approves all the decrees which will be issued by the government, right? So this is a provision which is completely unconstitutional, right? So I'm not questioning the necessity of introduction of the emergency, the constitutional emergency, the first in March 2020, because there was political agreement. Society agreed that it must be introduced and measures must be taken. And even the opposition at that time, they said that, okay, we can let us just write some date in the act, the Coronavirus Act. If it is not 15 days, as it is in the Constitution, let us write 90 days. So they were like, yes, I understand the gravity of the situation, that executive must act quickly, but I want to retain some oversight function. So if you want, we can extend the 15 days until up to 90, but then it was not adopted or accepted by the government. And that's why the Coronavirus Act had that rule that didn't mention at all 15 days or 90 days, but said that the parliament accepts or approves anything which had been done and which will be done by the government. And that is concerning, right? So it is unconstitutional. And the other issue with this introduction of the first constitutional emergency in Hungary was that if you have a look, the first paragraph, it identifies 2 grounds based on which an emergency can be this type of, we have 6, this type of emergency can be introduced. And the grounds are natural disaster or industrial accidents. And now those who are saying that the introduction of the first constitutional emergency was unconstitutional, they argue that the pandemic is neither a natural disaster nor an industrial accident. So based on this understanding and interpretation of the causes of the emergency, constitutional basis of the emergency, the actual first constitutional emergency situation couldn't have been introduced in Hungary constitutionally. Okay, so what I try to say is in the presentation, which was not clear, obviously, because I had a limited time, is that the first introduction of the emergency was de facto just justified. Basically, it was agreed on by all the actors, the necessity, but from a constitutional law perspective, it can be said that it was controversial, yeah? So I was not saying that the introduction of the first constitutional emergency was unjustified. On the other hand, I think that I'm saying that this extension of the third constitutional emergency is unjustified, yeah? Based on the actual things which are happening, vaccination and opening up of businesses and the like. Thank you for these excellent questions. And I hope I could now clearly explain the constitutional background of the Hungarian situation.
Thank you, Professor Drinotzi, for your very nice answers. It's very comprehensive. So we received some other questions. For Professor Sainsbury, The question is that in your speech, you stated that in UC, there are cases that are handled by the Faculty of Law, if I'm not mistaken. Yeah. So would you mind to share with us? Is it like an obligation for every law faculty in Australia to help the justice seeker, especially in this pandemic time? So that's questions for Professor Sainsbury. And also there is one question for Professor Martita. Professor Martita, in your speech, you stated that the Indonesian Constitutional Court is a court that not only serves for procedural justice provider, but as a substantive justice provider as well. Could you please explain why that the Constitutional Court in its decision emphasizes more substantive justice rather than just procedural justice? So that's the question for Professor Martita. And Professor Drenotsi, I hope you wouldn't mind if I share a question or two questions from Mr. Laga. So Palaga, I will choose two questions from your questions. Professor Drenotsi, should we expect that they will remain in place even after the acute phase of this crisis? So the question is like a prediction probably. And then can you please explain the idea of bare life and how it relates to what is happening today? So Mr. Laga's question to Professor Drenotsi. So yeah, I will probably Professor Sainsbury, you would like to respond to the question raised about cases handled in UC. Yeah, thank you, Professor.
Terima kasih. Yes, I think that's a very good point, that being in a pandemic does really raise obligations on the part of all of us to be doing what we can to assist. I think in general that we should be educating our law students to understand their responsibilities to the community, that they're in a privileged position to be able to be getting a tertiary education and to be getting legal qualifications, and that there's really a social contract that comes with that they need to be giving something back to society, and always being conscious of the need to be working for social justice and not just for their own self-interest. I think that universities, that's our primary role. It's to be educating future professionals that have that viewpoint. Beyond that, I think that we need to be aware that universities are also doing it very tough at the moment, and that really limits the contributions that we are able to make, that we're really responding and thinking of ways that we can support our students and educate them effectively in a new environment. We've also got in Australia in particular, all the universities have suffered a drastic decrease in international students that can't come and study here, and that's affected university budgets. So we would love to be helping more, but I think at the moment our focus is on supporting our students. But I think you're right, we shouldn't be losing sight of our obligations to society and making contributions within the regions and the areas that we serve.
Professor Sainsbury, for your answers. So yeah, university also plays an important role, I guess, in this kind of situation. So Professor Drinotsi, I'm sorry I cannot write on the message, but is it okay if I read the questions again? Okay. So Mr. Laga's question, can you please explain the idea of bare life, and how it relates to what is happening today? And the second one is that, should we expect that I guess they will remain, refers to social distancing probably. Should we expect that they will remain in place even after the acute phase of this crisis? Probably the peak time of the COVID pandemic, probably he refers to that.
Okay, thank you very much for these questions. I'm still not quite sure I understand them, and so I think that they are asking about what I think about whether the state of exception would and all of these measures would remain in place. I think that these were the questions basically, and I think that yeah, I mean we should make a wise decision. I mean states or policymakers need to make a wise decision here, because obviously there must be certain measures or practices which could be maintained, and others obviously should not. And just referring back to the presentation, in which I didn't elaborate on the virtual meetings or online meetings in the parliament, certain cases I could imagine that certain digital solutions could be used also in the future. On the other hand, I really don't think that that the executive could unnecessarily just keep their power and just do whatever they want to do, especially in those states which are like tend to be in their democratic decay. And so I think that would be my answer to that. Thank you.
Thank you, Professor Drinotsi. So for our other audience, if you would like to ask question, please rise from the emoticon in your computer. So we now go on to Professor Martita to answer the question raised. So Professor Martita, the screen is yours.
Thank you. I will answer the second question. Constitutional Court is a court that not only serve for a procedural justice provider, but as a substantive justice provider as well. Could you please explain what the Constitutional Court in this decision emphasis more substantive justice rather than just procedural justice? The Constitutional Court is present as a breaker of the deadlock of the apprehensive condition that are currently happening in our society. That is by making decisions that are positive legislation and decisions that are conditional. Substantive justice become fixed prize in the Constitutional Court. Selection Justice Substantive by course constitution background profusely demand order the Constitutional Courts give decision that give the solution law on uncertainly by provision that multiple interpretation to something principle or the rule law or on moment occur and this law. Thanks.
Thank you, Professor Martita. Now we are still waiting for the questions from the audience. So, however, is it okay if I myself ask a questions again, Professor Sainsbury, Professor Ginozzi? Yeah, to Professor Sainsbury, in your speech, you stated that every states in Australia has different regulations. So what are probably the methods that are used to be the measurements in every state in Australia to establish regulations to small medium enterprises during this COVID-19? So yeah, that's
Thank you. So what we do see is that in some areas there'll be a greater amount of cooperation between the states and territories to enact laws that are identical. So for example, with consumer protection, where they're not within the Commonwealth jurisdiction, then it's seen as advantageous, obviously, to cooperate because we need consistency in laws regulating business across Australia. But then in other areas, such as tenancy, you will see some differences. And the other area that I think is possibly the most confusing is what court do you go to enforce your claim? So that will be different depending on where the claim arises, and the court structures are quite different depending on the state or territory that you're in. So while we might have consistency in the law, then the processes to enforce the laws are possibly adds another level of confusion.
Thank you, Professor. So yeah, there is a question for Professor Ginozzi. So Professor Ginozzi, in your presentation, you stated about regulatory impact assessment or RIA. Could you please give more elaboration, like for example, in actually you've mentioned that before, but probably an example when a regulation is established by the Parliament, probably using that regulatory impact assessment. So thank you, Professor.
Thank you very much for this a very important question. What I would like to start is that in our system, in a parliamentary system, usually the majority of the proposals, the draft laws, are coming from the government, and that's why usually it is a line ministry which is responsible for developing the draft law, and it is very important for regulatory purposes to choose the possible best option when you want to regulate something. So first you have to see and have to realize that there is a problem in the society, an issue you want to address. And then obviously you have to reveal the reasons of that situation. What are the causes of that situation which requires regulation? And then also you have to decide if you need to use the law to address the particular issue or not. So once it is the law, so you have to make a new law or amend an existing law, or at the end repeal something. Then you will come up certain solutions. So I can address the issue like this, I could address like that, but then your priority is that you would have a policy goal, and this would be that you want to effectively address the issue. So you want to change the society or that particular issue in the society in a certain manner. And for that, you have to know, because obviously you want to produce a law which is able to achieve this goal. And for that, you have to know whether your prospective law will be able to achieve the goal. And how you would know that? You will know if you make a regulatory impact assessment. So you will assess the future effect of your draft law, of your policy idea, of your different versions of the draft law, for instance. And it is very important for you to know, because otherwise the piece of legislation will not based on evidence, and you cannot assure yourself and the citizens that that law which you are about to develop and about to submit to the parliament is the one which is most probable to achieve the goal which you want them to achieve. And so for that, there are many type of measurements. You can have a look at the budgetary effect. You can have a look at how it would impact the enterprises, small companies, big companies, for instance, administrative burden of citizens and companies, how it would affect the human rights of the citizens, how it would affect, as I said, the environment or the rule of law. And then there are methodologies for that. And then you collect information, you do the assessment, and then you will have reports. And based on the reports, the staff in the ministry or with the politician or with the minister, depending on the issue, can make an evidence-based policy choice, or they can make an evidence-based decision about the particular direction their draft law would take. And this is very important, because then you can show that you did your best to reveal all the causes and reveal all the possible effects of your legislation, of the prospective legislation. And what is very important enough to do this assessment in the beginning, right? But you have to do some periodical review of your legal system, or you have to, which we call like ex post evaluation of laws, when you already have a law in effect, applied by courts, authorities, whatever, and then you have a look at the law and you have a look at the actual effect the law made in the legal system on the environment, on enterprises, on administrative burdens, and the others, right? And then it will inform you whether you made a good choice or not. It will inform you about certain effects of the law which you didn't anticipate, or you wanted to avoid but you couldn't, and then it would feed this policy cycle, the legislative cycle, and then it will make you want to address this existing situation in the legal system. So you want to make amendments, you want to make new laws, and so on and so forth. And I use this expression ex post evaluation, which is in a parliamentary system, for instance, from my region, it would be the job of the ministries who are originally responsible for that particular piece of legislation, the preparation and follow-up. But the other name of this ex post evaluation is the post-legislative scrutiny, which is basically doing the same, but in the parliament, and other method or other type of ex post evaluation of laws is the sunset, the so-called sunset legislation. Then you have sunset clauses in your laws which are saying that I will expire, I don't know, in a couple of years, in 1, 2, 3 years, and then before that, the parliament and then all the actors are reviewing the actual effects of the law, and if they want to keep it in force, then they can. If they don't, then they can address that particular issue again based on evidence. Yeah, so it is a cycle, and it needs to be seen. The lawmaking process needs to be seen as a cycle. Yes, thank you.
Complex, and it has to be sustainable. So yeah, so thank you so much for your very impressive explanation. Actually, we have a questions from one of our students. His name is Malik, but Malik, I'm very sorry because of the limited time. It's actually at where Professor did not see now. It's 30 minutes past 2 o'clock in the morning, Professor Dinotsi. Is it correct? So, thank you so much for your availability in such time. So yeah, before we end this panel, we would like to have your final remarks from Professor Dinotsi, Professor Sainsbury, and Professor Martita for just about 2-3 minutes. So, Professor Dinotsi, the screen is yours.
Thank you very much.
Thank you very much, Prof. Dr. Tema Drinosi from University of Pécs, Hungary, and thank you very much, Prof. Mary Sambruri from University of Canberra, Australia, for your presentation and your operation. And really appreciate it. See you on next event at the Faculty of UNES. Thank you.
Professor Martita is very excited to have a meeting with both Professor Dinotsi and Professor Sainsbury in the future. We would like to have you here at our faculty. So thank you, Professor Martita. The screen now is yours, Professor Dinotsi.
Thank you, and sorry for the other thing just 1 minute before. So thank you very much for this invitation, and I'm really happy that I could participate in this session. Actually, I learned a lot, and thank you for again inviting me and this opportunity. And I hope that I could give you some new insight or perspective. I enjoyed being here very much. Thank you.
Professor Sainsbury. Sorry, yeah. Could you?
Thank you. I think you were on mute then. I couldn't work out whether you were asking me to speak. It's the first time that's happened all afternoon, so that must be a record for a Zoom meeting that's this large. Yes, so I've had a very enjoyable time talking to you and also listening to you. So thank you very much to all the staff and students that have been listening and to the other speakers as well. And I hope we can all continue to work together to solve some of these new and complicated problems, and that we'll be doing it in person next time. Thank you. I think you're still on mute, Ira.
Thank you so much again for your availability to join this conference. We have such incredible speakers today. I think I shouldn't make a conclusion, because I think from all the speeches and the questions and answers from all of you, the audience can draw many important points. But if I'm allowed to say, is that we should work together during this pandemic time. Hopefully we can recover soon after this pandemic. So thank you for once again, and my apologies if there is any inconvenience. So looking forward to see you again soon, Professor Drinotsi, Professor Sainsbury, and Professor Martita. So good afternoon, good morning to you both. Intan and Imam, the floor is yours.
Okay, let's give a round of applause for Mrs. Irawati, PhD. And also all of the invited speakers for the first panel session. Thank you again. Ladies and gentlemen, now we will have a break for about 5 minutes, and we will have our second panel session and also question and answer at 12:30. Again, at 12:30, please be here at 12:30. Okay, ladies and gentlemen, see you and enjoy your break.
Akan ada masa di mana kita menjalin rasa manusia dengan semesta. Mendaki ke puncak tertinggi, menggapai tujuan dengan kerja keras dan strategi. Perjalanan mengajarkan banyak arti dalam setiap langkah yang terlewati. Bercerita lewat asa untuk terus dijaga.
Manusia sejatinya berencana, menata cita-cita dalam bingkai rencana. Percaya bahwa keindahan tercipta bukan instan, melainkan lewat prinsip dan pedoman. Kreativitas dan imajinasi saling berkolaborasi, mengasah naluri, menjamah potensi. Tak akan bertemu ujung untuk apa yang kami kejar. Tak akan tercipta rasa tanpa belajar. Apa yang kami lakukan berawal dari sebuah ilmu yang kami emban di rumah peradaban, Universitas Negeri Semarang.
Kemajuan kita sebagai bangsa tidak bisa lebih cepat daripada kemajuan kita dalam pendidikan. Pikiran dan wawasan menjadi sumber daya fundamental.
Di sini saya belajar banyak hal, seperti mempertajam kecerdasan, memperkukuh kemauan, dan memperhalus perasaan.
Pendidikan adalah senjata paling ampuh untuk mengubah dunia, termasuk Indonesia. Berangkat dari mana? Ya dari diri kita sendiri.
Inilah rumah ilmu pengembang peradaban, tempat tunas penuh talenta tumbuh bermekaran dalam kasih sepenuh hati, bertumbuh menemu arti. UNES Gemilang untuk Indonesia Maju.
Gemilangan memandu UNES dalam melahirkan generasi berkarakter dan berprestasi, agar tunas muda Indonesia bertumbuh, menemukan peran dan makna demi kejayaan Indonesia dalam peradaban dunia.
Setia mengawal semangat perubahan demi kemajuan bangsa dan peradaban, sebab kami percaya niat baik saja tak cukup. Denyut inovasi harus terus berdegup. Arum luping pawiyatan ing astoniro, semangat ini berdiam di hati, terpatri di jiwa kami.
Selamat datang di Universitas Negeri Semarang.
Gemilang untuk Indonesia Maju.
Selamat datang di Universitas Negeri Semarang. Gemilang untuk Indonesia Maju.
Okay, good afternoon, ladies and gentlemen, all the participants. Welcome back to the 4th ICILS. And this afternoon, after the break, we will have the second panel session. And we are going to listen to the presentations from the two presenters, one from University Technology Semarang, Malaysia, and from South Africa. And we will invite again our moderator, Mrs. Irawati, PhD. The screen is yours, please, Mrs. Irawati.
Thank you so much, Imam. Good afternoon, ladies and gentlemen. Thank you for joining us again for our second panel. So for this panel, we have two speakers, invited speakers. The first one is Dr. Siti Hafsyah Idris. Hello, Dr. Siti Hafsyah Idris.
Hi.
Hi, how are you, doctor?
I'm good. Hope you're doing fine there.
So how is in Malaysia at the moment during this COVID pandemic?
We are during a period of 2 weeks lockdown, total lockdown, because we need to contain the spread of the new variant of COVID-19. So the cases still high. Until yesterday, we still have 6,000 cases yesterday with the rate. So we really hope that due to this lockdown, we can reduce the number, and also we can reduce the spread of the virus. And in fact, I'm in charge of student affairs, and our students also are infected. And yes, even though we are praying for very hard. So we hope that this pandemic will end soon.
Yeah, amen. Thank you so much for finding your time during this situation to join the seminar. And
it's my pleasure.
Thank you. So we also welcome Professor Jacco Barhuizen from University of Limpopo, South Africa. So, hello, Professor.
Hello, everyone. Salam, salam. I hope everyone is well. Hello from a cold, wintry South Africa where it snowed on the mountains. So whoever
it's snow there?
Snow in Africa. Whoever said climate change isn't real should come here. So it's really cold. I'm glad to be here. Hope everyone is staying safe and healthy.
Hopefully to you too, Professor. Thank you so much, Professor. So Professor Jacco, Dr. Siti Hafsyah Idris, my name is Irawati. I'm the moderator for this today's seminar. So it's an honor for me to become the moderator for this panel. So as this is the second panel, so we should go just, I think it's better for us to proceed speech from both of you. So before that, please allow me to read your remarkable track records from the educational background and for publication and your academic activities. So for the first speaker for this panel is Dr. Siti Hafsyah Idris. Dr. Siti Hafsyah Idris is from Faculty of Law, University Technology Mara, Malaysia. Her educational background, she got her bachelor degree with honors from University Technology Mara, her master degree in legal aspect of genetic engineering and biosafety from University of Malaya. And her PhD degree was conducted in law faculty from University Technology Mara, focusing on research in the bioethical issues relating to genetically modified crops in protecting farmers' rights. Her research areas, among others, biosafety law and bioethics, environmental law and policy, mental health law. And at the moment, she is the Deputy Dean for Student Affairs at the Faculty of Law, University Technology Mara, Malaysia. She has many publications, some books, articles, so among others, I just will read about her articles. One of them is Beyond Ethics, Human Rights Approach in Mental Health Issues. So she wrote this with her colleagues. And then we also have Professor Jacco Berghuizen. Professor Dr. Jacco Berghuizen is an associate professor and head of department in the Department of Criminology and Criminal Justice at the University of Limpopo. He is also the chairperson of the Faculty of Humanities Multimodal Teaching and Learning Committee at the University of Limpopo, and was also recently appointed as non-permanent visiting professor in Indonesia. He graduated with a bachelor's in art degree with major in psychology and criminology. And after this degree, he received a bachelor with honors degree in psychology from the University of Port Elizabeth. And a year after that, he also graduated with the degree Bachelor of Arts with honors in criminology from the University of Pretoria, South Africa. And then he enrolled for his master degree, Master of Art in Psychology at the University of Pretoria. After that, he pursued his doctoral aspirations at Tokiwa University in Mito, Japan. His doctoral focus was on sexual molestation on public transportation, a victimological approach. And this research culminated in him obtaining the first recognized dedicated full doctorate in human science victimology, which led him being selected as the first non-Asian valedictorian at Tokiwa University, Japan. And his current research interests are victim rights, and specifically victim rights in South Africa, human trafficking in South Africa, and serial murder in South Africa. And there are other research areas that he is interested in. And then he has published in numerous journals and book chapters in South Africa, India, Japan, and Indonesia, and some other countries. So without further ado, for the first session on this panel, I would like to ask Dr. Siti Hafsyah Idris. Doctor, the screen is yours.
Thank you, Ms. Moderator. Thank you for the organizer, the UNAS FH, for inviting me to this conference as one of the speakers. Actually, Indonesia is my second home. I used to go and back to Indonesia, particularly to Surabaya, I think more than 3 times a year. But since COVID-19, I haven't yet go back to Indonesia because I have a project in Elangga, and then most of the time I'm in charge of the student affairs. I'm take care of my student in Elangga Universitas. So thank you so much. To begin with, my topic today is actually on the rights of the farmers with regards to genetically modified organism. So this is actually my master and my PhD research. And now I extend this research to my research grant, and also I have supervision, PhD supervision, my students. So this is my colleague who is doing a research with me for this grant. So it's actually on the biosafety part of the genetically modified organisms, but specifically I focus on genetically modified crops because it's more pertinent of this issue in Asian country, particularly with regards to, because we are Asian country, we are agriculture. Agriculture is our main economy development. So my focus is actually on genetically modified crops, which I will share after this what is genetically modified crops. And looking into, if in my PhD, I'm looking into the bioethical issues, because I think on the legal part, it has been settled. It is covered under the law, but there are some issues that is not covered yet under the law, but particularly on the socio-economic impact and also the bioethical impact. So now the impact is not only to the environment, but also to the human rights. So what we focus here is actually on the farmers' right, because they are the person, the stakeholder, the main stakeholder in agriculture industry. So, so as a background, okay, biotechnology, because what is genetically modified crops? Genetically modified crop is actually a product of genetically modified organism, which has been developed through modern biotechnology. So biotechnology in Malaysia is actually an thing issue now. Okay, we are moving towards biotechnology. We're moving towards the modern biotechnology because of food security. Okay, due to climate change, due to environmental issues, so we need food security. In order for to enhance the food security and to secure that all nations get food security foods, so we need to develop this technology. Nevertheless, this technology has of course, it has advantage, but at the same time, it's also come together with the potential impact. So this modern technology is actually one of the modern technology produce genetically modified organism through genetic modification, whereby gene or bacteria from we insert alien genes into the crops, into the organisms, so that it can be compatible, for example, with the weather. Okay, and then we need a sustained, for example, a sustained fruit, for example, on corn and also paddy. So we need a new strains of paddy which is sustained to the weather, to the climate change. So we need this. Unfortunately, okay, and then I don't go with the cross-pollination and farmers right yet. So biotechnology in Malaysia, we have the Malaysian biotechnology policy, and then it is divided into 3 phases. And then now actually we've done with the capacity building and also research market transformations. So now we are actually for GMO itself, we have more than 59 applications that has been approved by a National Biosafety Board. So this include the field trial, this include the food feed and processing, and also for the research. So it shows that Malaysia is moving towards the usage of genetically modified organism, particularly on genetically modified crops. So biotechnology, modern biotechnology has been listed as 5 of main innovations to help Malaysia to develop as a developed nation, and then also to achieve SDG to 2030. So modern biotechnology is actually in the National Biosafety, National Biotechnology Policy, as well as we as a signatory to Convention of Biodiversity Convention. So we have the duty to develop this technology. So this technology, genetic modification, as I mentioned just now, it transfers a portion of DNA sequence code by a gene into a specific organism. So it means that it will create a transgenic organism with an alien feature, with a new feature in that particular organism. So with these introductions of aliens, I mean, a new features in the in the new features, with the introduction of these new features in the organism, there's something wrong with my sound? Or
yeah,
may I proceed?
It's not, we cannot hear that sound anymore, Professor, Dr.
Okay.
Yeah.
Okay. So with this, we don't have a problem because actually the issues has been addressed on the human health issues and also the environmental issues. Yes, of course, it has so many benefits with these GM crops. Okay, we have no doubts on this. So that is why it's been developed. And also it has a potential impact to the environment. For example, it can invade the environment with a new variety of, for example, we do not know whether it's susceptible to the environment or not, whether it can impact the soil, okay, and also to human health. Maybe perhaps some people are not prone to some foods, okay. If this food, for example, if you go to supermarket and then you can see that this food or this soy does not contain GMO, so it means that it has a label, it has a disclaimer that their product is actually free from GMO. And then in Europe itself, they actually, they're really particular about this. And then they will label the food, whether the label contains GMO or not. So because this involves public health, okay? Because sometimes if you are not, if you are allergic to nuts and then some elements, some features of nuts actually have been inserted to certain food, for example, in tomato, for example, and then you eat the tomato, even though you will never allergic to tomato, perhaps you will develop some reaction, some allergic reaction due to that alien, the insertions of the genetic gene. So that one is actually been resolved. Then that is why we have the Biosafety Act. So Malaysia, we do have that Biosafety Act. What concerns us now is actually on the cross-pollination. So the cross-pollination is actually our biggest problem, our biggest concern, because we want to protect the rights of the farmers, because we have two types of farmers. One farmers, they want to a conventional or traditional seeds. They want to maintain whatever they have now. They want to maintain that whatever method that they have now, the traditionals, and then they don't want this seed, because if you see here in Malaysia, and also I think in okay, here, okay, in 2019. So the total of 54 community and farmer organizations, okay, submitted a memorandum of protest for the National Biosafety Board, because this Biosafety Board actually in the process of considering whether the GM rice should be carried for the field trial. So these farmers and this community, they doesn't want this actually, this trial to be conducted, because we do not know the impacts to the environment, into the neighborhoods of the, and then the area, the plantation area of the farmers. So what is the impact of this cross-pollination? And then because if we see here, cross-pollinations, it can, because crops, the pollen can, it's a natural process. So without pollen, food would cease to exist in the current form. So via these cross-pollinations, the conventional or organic farms will be eventually contaminated with these GM crops. So we do not want that. So what happened in Australia back in 2015, based on the case of Marsh versus Baxter, these two neighbors actually, one planted organic crops and another one is on GM crops. So even though, okay, if we see here, the photo here, even though it's not so close, okay, they have a buffer zone here, but still the pollen can fly and then it can go to the conventional or traditional or organic farms. So due to that, okay, and you have to remember that these GM crops actually is patented. So whenever the farmers who buy the seed, they need to sign a license, they need to sign an agreement to say that they won't replant, reseed, or resort the seed. They need to for every season, they need to buy a new seed from the producer or for the developer, so, or the supplier. And they have a patent because it has been patented, this GM crop. So what happened in Australia in 2015, when this actually cross-pollination happened, the organic crops found to contain some features of GM crops from the neighbors who planted this GM crop. So he has been sued, and then compensation has been requested from the organic farmers. So in this case, actually, they are not in the, it is due to the negligence or to the of the natural process of the environment. But because he has this trait that contain GM crops, then the other farmers and then the company who own that seed actually claim compensation from these organic farmers. And at the end, even though the organic farmers claim for negligence, claim for compensation, he failed to get that, but eventually he did not have to pay for the violations of the copyright. But again, this case shows that what if the remedy for the liabilities and redress for the farmers who has been planting these conventional and also these organic crops, and this crop has been contaminated with the GM crop. And another thing is, when we claim that, when the farmers claim that their product is actually organic or traditional and not contain GM crops, GMO, but with this cross-pollination, can it cause contaminations, and what will happen to their plant? So it can cause loss to these farmers because it has been contaminated, and it can incur the economic cost to the farmers. For example, in 2019, Malaysia actually export fruits to China, and China, once received the fruit, they return it back to Malaysia, claiming that this food has contained genetic modifications, GMOs. So whereby Malaysia never approved the field trial of GM fruits, any field trial, no yet. But it has been contaminated by any way, which we do not have the answer why it has been contaminated, this fruit. So this shows that economic loss to the farmers. So this is also one of the rights of the farmers. Okay, and then not only that, what another issue is actually on the IP, because even though they are not, as I mentioned just now, even though they are not subjected to the IPRs as intellectual property rights of the GM crops, but because they contain, due to the cross-pollinations, and their crops contain this genetic gene from the GM crops, that it can be sued. They can be sued. For example, in one case in US, they has been sued because it contained the trait, and then they keep saving the crops. So yes, they are open to be liable if the farmers, conventional farmers, keep the seeds. And also, another thing is on the right to livelihood. If we see the right to livelihood, for example, in India, what happened was, when they plant these crops, the GM crops, and then they don't have money to buy, because it is, of course, it's costly. So they buy it again, and then but they can't afford to buy the seed again, and then they replant the seed. So when they replant the seed, it doesn't work. So because of that, it also incur cost loss to the farmers, and at the end they commit suicide. So this is also with regards to their right to livelihood, and also right to traditional knowledge, because they have the traditional knowledge on how to actually to produce their own plant. And based on our research on GM rice, okay, it can cause to soil pollutions, because once they planted with this new variant of these GM crops, okay, they actually cannot is very sensitive. The soil is not susceptible to another plant. For example, on the paddy fields, they can have another alternative, not alternative. They can have another crops, another plants on the same field. They can plant papaya plant there, and then they can also have cornfield there. So, but now with this, when they use this seed, which they do not know whether this is a GM crop or not, so the soil is not suitable anymore for another plant. It is only for the rice, for the paddy, paddy seeds. So it's not suitable for any other plant. So actually they cannot gain any increase their the value of the land, because it has already been contaminated by another things, another not bacteria by these GM crops. So that is the issues with the rights of the farmers. And then yes, of course, under the federal constitutions, we have protections under Article 5 of our federal constitution, whereby the right to livelihood. So in the case of Tan Teck Seng, the Court of Appeal said that right to life also include right to healthy environment and healthy from pollutions. So even though with these cases, okay, the act itself, we do have a Biosafety Act. Actually, this act is actually to govern and to regulate the activities of a genetically modified organism in Malaysia. And we also a signatory to Cartagena Protocol. And then we, the Biosafety Act is actually silent about cross-pollinations. We do not have any specific provisions on what will happen if there is cross-pollinations of GM crops. And then also we do have the Environmental Quality Act. This Environmental Quality Act is actually to control the pollution, but yet on the issues of genetic modification, genetic pollution, it does not been covered under the act yet. So we are still waiting for what will happen if there is cross-pollination in Malaysia pertaining to GM crops. And then I know that this research on GM crops, GM rice, they are developing it for years. So actually they want to see the effects to the environment and also to the human health. As I mentioned earlier, yes, this crop we need this crop. We need this development. We don't want to hamper this development, but at the same time, we also need to mitigate, because Biosafety Act, Cartagena Protocol, okay, actually based on the principle of precautionary principle. We need to also mitigate whatever risk that might be posed by these crops. So, as I mentioned just now, we do have the National Biosafety Board, where the application will be assessed by the Genetically Modified Committee, Modification Committee, Advisory Committee. They will actually assess whatever application that they have. And then we also need to see what is the liability and redress. Even the labeling, we do have the provision on labeling, but it's subjected to 83% if it contains more than 3% of the GM crops, GMO. And then on farmers' rights, there are farmers who are actually really want to buy, and then these are the farmers. We have two groups of farmers, and then these farmers, which they want to continue with conventional farming, they need to be protected. But I think not only them, but also the rights of the farmers who's planting these GM crops. They need also protections from these cross-pollinations if it happen in Malaysia. So we do not, we need to actually to preserve our own natural resources. If we have that, for example, we have durian, we have paddy, we have many types of paddy. So we need to actually to protect that so that it won't be mixed up with these GM crops. And then the market, and especially the global market, will reject, because it also involved with trade. Like what happened for our fruits from Cameron Highland, it has been written back to us, and it affects the quality and also the economic loss to the farmers and also to the country. So these are the problem statements. And then the research question, what we are doing now is actually we want to see the biosafety regulatory framework in Malaysia with regards to cross-pollinations. And I'm actually doing this also with Indonesia, because I believe in Indonesia, because I've been to IPB before this in Bogor, and then we went to one laboratory where they have been tested the rice, the strains for many years, but it's not been yet tested for field type. But I'm sure in Indonesia you have the sugarcane already, okay, sugarcane and also the soya. So we are looking, actually, my research actually looking into the frameworks that protect the farmers from these cross-pollinations. So, and also how should these biosafety frameworks can protect the farmers in Malaysia, particularly after we compare with other countries. So, so we compare, and then we analyze not only the Biosafety Act, but also we analyze the New Plant Variety Acts, Federal Constitution, Environmental Quality Act, and also Farmers Act. So we are looking into this area, and then the methods we are actually doing on doctrinal, black letter, and also qualitative, whereby we also do some empirical study, whereby we interview some of the farmers, and then with this lockdown and also COVID-19, this is our limitation to interview, but we can also do focus group discussion with the stakeholders to ask them about whether we should have mechanism, we don't have to have legislative measures. Maybe we can have strategies actually how to mitigate, and then how to protect mitigate the pollution, and also how to protect the farmers in this regard. So I will discuss on the methodology, okay, with regards to the conceptual frameworks, the literature review. Yes, we do have the law. Unfortunately, on part of the cross-pollinations and farmers' right, we still have a lack here there, and then there's a loophole that we need to fill in the gap, and then we look into the legal framework as by comparing with other countries on how we can actually propose a mechanism to enhance the law and also the enforcement. Enforcement is also very important, because like I mentioned just now, how can our fruits been exported to another country without us knowing that the fruit is actually contaminated with GMOs? So the adequacy law, they cannot protect farmers' rights. So that is why we need to fill in the gap for a legal framework, or at least we have a strategies, as I mentioned just now, to protect the farmers' rights. So as a conclusion, okay, there is still a considerable gap in the existing law, okay, particularly on the Biosafety Act and Environmental Quality and also Farmers Acts, to protect the rights of the farmers with regards to the cross-pollinations of the genetically modified crops in Malaysia. With that, thank you.
Thank you, Dr. Siti Hafsah Idris, for your enlightenment presentation. So it looks like the human have to limit themselves in exploiting the food also, because it cannot probably not beneficial for human body after all. Okay, thank you, Professor Dr. Siti Hafsah Idris. So I would like to give the screen to our second speaker for this panel, Professor Jeko Barhuizen Professor Jacko?
I am here. I'm just trying to unmute here. Let me just get to.
Yeah, Professor Jacko Barhuizen. Am I correct to pronounce your name?
Yeah, well, Barhuizen, but you're fine.
Thank you so much for your understanding. So the screen is yours, Professor.
Thank you very much. So my talk is a little bit different. My talk is about new technologies in criminology, victimology, and criminal justice, and its preventative or prevention strategy. Now, I love it that this is a law and technology conference because, like Albert Einstein said, if we knew what it was what we were doing, it would not be called research, would it? So this is it. What do we know? What do we don't know? And what we don't know is what we should know. So technology is the basis for all human evolution. My paper talks about strategies to reduce victimization caused by technological development. However, how we view technology does not necessarily mean it's your smartphone or a gadget. If you look at the things we're doing now during COVID and how we as humanity adapted and how universities adapted, we should realize technology is more than just a smartphone, more than just a new gadget. So in this paper, we talk about three hats. We talk about criminology, we talk about victimology, and then we talk about the criminal justice system, or as I like to call it, the justice system. We always throw the criminal out because the idea of the criminal justice system actually is to put the victim at the core of it. So calling it a criminal justice system is a misnomer. So a definition, why, how, and what. So we're going to talk about crime and criminology. We're going to talk about victimology, and we're going to talk about technology. Now, criminology is the scientific study of crime and criminals, of deviant behavior and violations of the law. Now, what is the problem of that? I hope the students start to see there's a problem with that definition. What is that? It's a legal definition. And then you have a social definition. So can something be a crime if it isn't defined either socially or legally? For example, we're going to talk about cybercrime. Cybercrime is a new crime, but it took very long for most governments, and Indonesia as well, South Africa as well, to recognize that cybercrime is a crime. So only in 2020 did South Africa have something called the Cybercrime Act. So only from 2020 onwards, if you were a victim of cybercrime, legally defined according to this act, are you a victim of cybercrime? Anything before that, yeah, sorry. So this is the problem when we talk about victims in crime, is we should rather talk about victimization or acts of victimization, cyber victimization, and so forth. So victimology, what is victimology? It comes from the word victima, from Latin, and logos from Greek, and it basically means the theoretical study about victims. So victimology currently, and I know some of your students and some of the professors in here have seen me say this before. The victimology is the scientific study of victims of human rights violations, including crime, of victimization and reactions of both victims and society. So the problem with this definition, it doesn't say who is a victim and what is a victimization. So who is a victim? Now, according to the UN Declaration, that's any individual or group that suffers a victimization due to the action and, very importantly, or inaction of another individual, group, or state act. We can take COVID as an example. How quick did your government react? How quick were they able to buy vaccines? Did they take long, like South Africa, which is an inaction, which is causing victimization on a grand scale in South Africa? So what is a victimization? A victimization is an invasion into the self. Now, this invasion leads to the individual experience harm to the self. Like if you imagine an onion, like every person is like an onion, or as I call it, the Shreks. Now, in an onion, it has all these layers, and then you have the pit of the onion. Now, what a victimization does, it cuts through all these beautiful layers of what you think you project to the inner core of the real you, and it has effects on you. So it has harm, either physical harm, psychological harm, emotional harm, financial harm, or social harm, which is a relatively new addition that we look at in victimology. With the rise of social media, so has the victimization on social media increased, so has social harm on social media increased. But social harm here is not just about social media. There's certain tribal areas in Nepal where virginity, for example, is highly praised. So what happens is some of these women get abducted by human traffickers and then forced into sex work. When they are finally rescued and released back to Nepal and their areas, they're not accepted because they're not virgins anymore. So that's a social harm. It's not these women's fault for being trafficked and abducted and being raped. And then now that they come back, the society doesn't accept them because of the social stigma. And that's also a social harm. So what is technology? I'm going to use a social science definition. It's the use of techniques, process, and material objects to produce goods, provide services, and importantly, connect people. Now, we have to remember technology is amoral. It is not good nor bad. It is a tool. For example, if you look at my presentation, when we discovered fire as humans, we learned to cook food, which led us to cook protein, which led to bigger brains. When we discovered the wheel, we built a car to move further. When we discovered metal, we started to build houses and cathedrals and stuff. When we developed steam, we developed trains. We developed boats that could go faster and further. Industrial revolution was driven by steam. Nuclear, we have, because of nuclear power, we have cures for cancer. We have all these new technologies that come from nuclear. Then we have the internet, which is sort of relatively new, the fourth industrial revolution. I'm sitting in the northern part of Southern Africa or South Africa, speaking to people in Indonesia and Malaysia. Isn't that amazing? Do you think this would have been possible 10 years ago? How about 20? So we connect. Everything is becoming more interconnected. But as everything's becoming more interconnected, so does crime and criminology studies and technology also affect that. We're in a changing landscape. And I mean, this applies to our law faculties as well. There is an interconnectedness, how we teach, we learn, and research. I just worked on an article with an Indonesian colleague of mine. They're in Indonesia, I'm in South Africa, but we can still do research together. I'm basically speaking to students now, I'm teaching. I'm in Africa, you're in Indonesia. And the guys learning are in Indonesia, listening to some random professor in South Africa, right? So with research, we have to look at the Turing test. It's a test of a machine's ability to exhibit intelligent behavior equivalent to or distinguishable from that of a human. Now, the Turing test was beaten in 2014. Now, we need to invest as criminologists, as law experts, and as social scientists in algorithms, intelligent algorithms that will help us with action research. We are so connected now that it's going to be easier for me to do research on victims in Indonesia if we invest in that and have certain equivalent in this side, and that interconnectedness will make our knowledge bases grow. Now, again, now I'm going to talk about the second part of how technology can cause potential victims. Now, remember, technology, I said, what is amoral. It's neither good nor bad. It depends on who you are and how you use it. When we discovered fire, we also discovered a way to burn people, burn their crops. When we discovered the wheel, we also discovered the idea of making war chariots to attack our neighbors. When we discovered metal, we also made swords. When we discovered steam, we also made better functioning guns. When we discovered nuclear, we discovered how to make nuclear bombs. When we discovered the internet, or when we made the internet, we have certain other things that's coming to the fore now. So every new technology or technological development has its good parts and has its bad parts. It depends really on the actor, the person using this. For example, in medicine, which is one of the oldest since humanity, there was someone practicing a form of medicine. But recently, we've seen the increase of bait rape guns, organ trafficking, human trafficking, potential cloning. By the way, just because of all the lockdowns all over the world and travel restriction, last year was actually a good year for human trafficking victims because no one could travel between countries. So interstate trafficking has gone down a little bit. Another thing that we're seeing now is the rise of fake medical procedures. People being told, I can give you this type of face if you give me this, and then what we also saw now in this pandemic is the rise of fake vaccines and vaccination hoax, which is part of this medical part of the medical fraternity where people will make fake vaccines for money. So this is, again, we have a pandemic and technology, and that interaction between a pandemic and technology is good, but it's also bad. It depends. Now with the internet and social media, what we're finding is the rise of phishing, the 419 scams, revenge pornography, also called revenge porn, the use of previous post histories for blackmail, then deep web, the rise of the use of deep webs and deep fakes for terror recruitment for the following things. So first, let me talk about the deep web. It's an invisible web. It's the largest part of the internet that's inaccessible to conventional search engines. So what we see when you Google stuff, that's only 1% of the whole internet. There's a whole dark subspace called the dark web, which is a network of untraceable online activity and websites on the internet. You cannot just find it. You need a special browser. You need a special virtual private network. And only if you have those things can you access the dark web. Now, what's on the dark web? And it's grown. The longer this pandemic is going on, the bigger the dark web and the things that you can find on the dark web is also growing exponentially. You can hire someone to murder your spouse or someone you don't like. You can buy ransomware. Recently, the United States oil pipeline was infected by ransomware, where the oil company had to pay some hackers in Bitcoin for the pipeline to function again. You can find red rooms, which is basically rooms where you can watch people being murdered and abused. You can find child pornography. Here I refer to the Candyland FBI investigation. That was the biggest dark web, deep web child porn investigation so far. That was all over the world, from the States, Canada, Europe, Africa, Australia, Thailand, I think Malaysia. It covered a lot of extortion, pedophile rings, drug trafficking. You can buy any form of drug on the deep web and have it shipped to you. Here I refer you guys to the Silk Road bust of I think it was 2014, where they found this guy advertising something called Silk Road, which was basically a website where you can buy any drugs. You can buy humans. You can learn how to make deep fakes. And then, of course, as we know, a lot of terror groups function on the deep web and the dark web. So what's a deep fake? It's a technique for human image synthesis based on artificial intelligence. Because of these deep fakes have been used to create fake celebrity, pornographic videos, revenge porn. It can also be used to create fake news and malicious hoaxes. Just for those of you in Malaysia that maybe have this face app where they take your face and put it on another face while this face is singing, and then you see your own face singing on this app. That is part of deep fake. And so with apps like that, the AI, the artificial intelligence, learns more of how faces look. So the more people do stuff like that, it's on one hand good, because we have artificial intelligence that get better at facial recognition. But on the other hand, you also have artificial intelligence understanding faces better. So malicious actors can take this artificial intelligence and this algorithm and put your face maybe on a pornographic image, or put the president's face on another person's face declaring war and post it on social media, and then the whole world goes to hell. So what's the consequences of deepfakes and deep web on victims? It's got social harm. I mean, think about it. If you've never been part of any pornographic image, and now suddenly there's photos that look so real, the social harm of that, the psychological harm, the emotional harm, the financial harm, because a lot of places would rather, jobs would rather have you leave their jobs if these images are floating around on the internet. And then physical harm, how you react or how your family would react to seeing all these images, or how people would react to seeing these images, could lead to physical harm. Now, again, and if you look at it from a crime perspective, again, technology is amoral. It's either good, either bad. It's how we use it. Now, with the rise of algorithms like deepfakes, we can also now have algorithms that give us real-time crime mapping and prevention. If you just think about your own countries, and I think all countries do this, is real-time COVID tracking, right? So every day we hear how many people are infected, what's the caseload and stuff like that, every day. Now, if we can do that for COVID infections, we should be able to do that for crime, and from there base our prevention on real-time crime data. We are interconnected. Why can we not? And this is currently happening slowly, but it is happening, have national and international databases that speak to each other in terms of pedophiles, violent criminals. I mean, violent criminals can move across countries just like anybody else. Sex crimes. Then when it comes to linkage analysis, link different crimes or crimes committed by one person together. Here you can think of the VICAP system of the FBI. And this linkage analysis, because if you look at South Africa and if you look at Indonesia, Indonesia have a lot of islands. South Africa, we're relatively a big country with different police stations. So if I'm smart, I'll commit a crime in Cape Town, then move to Joburg, commit a crime in Joburg, but in a certain suburb. And the problem is sometimes these different police stations that investigate crimes do not talk together. And it takes a long while. Now, if we use the algorithms that's currently developed, then we can quickly link these different crimes based on motivation or whatever together for easier detection and crime prevention. Threat analysis of crime and terror. There is programs that can do that, but it's not connected on a global scale yet. I mean, Indonesia has suffered some horrific actions of terror groups. The world has seen terror rise. 3 months ago, just our neighboring country to the left of South Africa had an ISIS affiliated group blow up a whole town and city and kill people and blow up oil refineries. So, but for victims, what do we have? We have apps that help with psychological trauma. You can talk with someone on an app now. You can connect and share stories as a victim. Reporting of crime. Again, see that real-time policing analysis. Currently, the world is still, or policing is still very slow. In Indonesia, and I think in South Africa, and I think also in Indonesia and maybe Malaysia, if you're a victim of a crime, you have to go to a police station to open a docket. Why? I mean, why can you not have police app? You put in what happened, you log it, and a policeman somewhere on their laptop or phone gets an alert, someone's been a victim of crime, let's go there. Let's go interview them. Then we have to talk about the criminal justice system as well. Since COVID, courts have been no-go areas, as in you couldn't go in because of lockdown restrictions and stuff like that. So how did courts react or evolve? Well, I don't know if that happened in Malaysia and Indonesia. A lot of court cases in South Africa was run via Zoom. So you had the judge in his chambers or at his house, the accused, the defense on the one hand, and then the prosecutors on the other hand, via Zoom. Now that was just emergency, so laws need to be changed to allow this. But think about it, how more affordable it will become for the accused and the victims if we keep on with online access to the justice system, right? It's more proactive. Why do we have to wait for disasters to enforce the basic human rights of equal access to justice? We have the technology, we're doing it now. If you think of cost orders, just in terms of justice and how cost orders are used, and one of the things is also the time of the judge and the use of the electricity of the court and whatever. So that should go away. It will make justice more affordable. On the other hand, the other question is human rights. if you don't have access to Zoom, or Zoom or whatever platform, would that not be a violation of your human rights? I'm not saying do away with courts altogether or the physical buildings altogether, but make it more accessible, which we can through technology. Now, I'm finishing off now. Another thing that's growing and that should be part of police, it should be part of disaster management, is drone technology. In South Africa, we have hijacking hotspots. So if you drive your car there, the chances of being hijacked is high. So we can use drones to hover there. During natural disasters like tsunamis and earthquakes, you can have a drone easier, quicker in an inaccessible area and deliver food or to look at the damage that an earthquake has caused or a tsunami has caused. It's quicker, it's easier, and it's not as expensive as a helicopter. And if a drone crashes, it's a drone. It's not someone in there. But if a helicopter crashes, it's at least 2 pilots that are dead or hurt. Also during the pandemic, you don't have to have a physical person in front of a shop scan you for your temperature and make sure that you can have a drone just hanging there, scanning people as they go in. What we also see is the rise, and that comes back to also social distancing, non-lethal crowd control, the use of sonic devices or long-range acoustic devices to keep people apart, to have crowd control, where this thing, if they put it on and you're too tightly together and they direct it at you, you get physically sick. So it's not like in South Africa where we are a water scarce country, but when people protest and there's big crowds, we'll use water cannons, but we don't have that much water in this country. Or we'll fire rubber bullets, which is supposed to be non-lethal, but rubber bullets shot incorrectly can kill. Or we throw stun grenades. Again, a stun grenade, non-lethal, but if it falls next to you, it can kill and hurt. So we also saw the rise of non-lethal personal control, tasers and e-bullets, body cams for the police, which is a brilliant idea. Not only does it protect the policeman, but also the potential offender and victim, that there's proof of how people interacted. And this rise of this, especially as an evidentiary tool, will grow, and we need laws to regulate that. Then the rise of artificial intelligence and deep machine learning, especially when it comes to policing, the Turing test. The effect of this will be far-reaching for policing, and how we understand offender behavior, how we understand victimization behavior, and how policing reacts to that. And then with facial recognition technology, and I'm using Japan here as an example, not China, I'm talking about democracy. The easier to help people, to recognize Jane and John Does, to pick up people that might have been hurt and missing, old people. Making sure that when you go to a bank, the person withdrawing the money from the account is actually the person whose face it is. Yeah, my conclusion here is like, as this pandemic progresses and as we are more trapped at houses or in areas, the more technology will grow, the more interconnected we will become. Already, I'm in a conference in Indonesia while sitting here. So it will become more. And we need to be prepared how this technology will be used for good and for bad. And for that, we'll need better laws. We'll need better law students to make new laws. We'll need to think outside the box. And yeah, thank you very much. That was my presentation.
Miss Irawati, I think you have to switch on your mic. Your microphone is not on.
Oh, okay. Thank you, Dr. Siti Hafsia Idris. Yeah, sorry for the technicality problem. Thank you for your fascinating presentation, Professor Jacob Berkhuizen. So we have about 60 minutes for questions and answer session. We welcome any participants to ask question. You can write on the chat box. So at the moment, we have received some questions. The first one is for Dr. Siti Hafsia Idris. It comes from Mr. Ubaidillah Kamal. So his question is to Makcik Siti Hafsia. How does the law in Malaysia ensuring that genetically modified products are not harmful to people's lives?
Before I respond these questions, perhaps this is perhaps with regards to a different culture and different language from Malaysia and also Indonesia. Actually, makcik is auntie in Malaysia.
Very sorry. So what should we call you?
Normally, is for ibu. Ibu is actually puan.
Puan. Yeah, thank you so much for your.
It's okay. It's okay. It's actually always happening. So it's normal. Some people they misunderstood the language. Okay, with regard to this, how does the law in Malaysia ensuring that GM products are not harmful to people? That is why we have the Biosafety Act. Okay, the Biosafety Act is actually, as I mentioned earlier, it's a procedural act whereby it really ensures that for all the application and also for all the notification, for all the approval, must go through the Biosafety Board. We do have a National Biosafety Board under the Biosafety Department. So this Biosafety Department is actually under the Ministry of Environment and Water, and under the Act itself, it established the board whereby this board is actually to monitor and to assess all the application pertaining to GM products and GMO. Anything on GMO, they will go to this National Biosafety Board, whereby the National Biosafety Board will assess all the application for approval and also for notification on research. And this board will be assessed by the genetically modifications committee. Okay, and then I'm also been offered actually to be part of the social and economic committee to assess of the application to make sure that these products are not harmful to the environment and also to human and also animals' life, because that is the objective of the national of the Biosafety Act 2007. The objective is actually to protect the environment as well as the human and animal health from the adverse impact of the GMO. So we do have that, and then that is why my research is actually looking into the liability and redress of cross-pollinations, because that one is not been discussed yet, even though we do have that in the Act, but it's not yet been finalized on that issue. So we also have not only the procedures, but also we do have the labeling, as I mentioned just now.
So thank you, Doctor. So before we some more question for you, Doctor. So there are also question for Professor Ivan. Professor, is it? Hello, Professor. Yeah. So there is a question. Do humans have to limit the development of technology because we face some unbeneficial because of the technology, I believe?
Do we limit the development of technology? No, it will be impossible to limit technology. We just need to know that for each technology, there's a good and there's a bad. I mean, when it comes to the bioethics of cloning, and we have an expert here on bioethics, we can bring back close to extinct animals that are going out. But should we clone humans? No. But should we look at using cloning, for example, to bring back close to extinct animals? Yes, why not? We should not limit technology. We should just be cognizant that for every good, there is a bad. Like humans, for every good human, there's a bad human. You know, humans are as unique as technology. Someone will see a technological advance for the benefit of humanity, and someone else will see it for the benefit of themselves. I hope that addressed the question.
Professor Barkizan. Dr. Siti Hafsah, probably you have an opinion on the question.
The question again, Ms. Irawati?
Yeah, it's actually rise to Professor Jacob Barkizan, but probably it's a valid question for you also, because the question is, do humans have to limit the development of technology? Can respond that in relation to your research about the genetically modified?
Okay, as I mentioned just now, we do not want to hamper development. And then to achieve SGD, even for SGD 2030, we have 70 goals that we need to achieve. And then, as I mentioned, food security is needed. And then also with the climate change, we need this technology. But we need to actually to develop this technology. I don't want to say that we do not want this technology. We have to stop the technology. It's not sustainable. So we need to have it, but in a sustainable manner. So we have to, like we have the 3 cycles of the sustainable developments. This is for the economic justice and also for the social equality and also for the environmental protection. We need to develop the technology hands in hand with these three pillars of sustainable development. So if we stop development, then what will happen to our economic, for example? Okay, because we need that. Our people need that. Our nation needs that. The development, okay, sooner or later, it will come to us. And then also we need to also remember the rights of our future generations. And with all this COVID-19 thing, I think there's so many things, so many developments, so many innovation will be developed. I may say that because we wouldn't know that before we have to face like this for our conference, right? We have to be very innovative in the future. But as I mentioned again, we need to do it in sustainability manner. For example, for this technology, okay, because my area is also on mental health issues, this technology. With this technology, when we have this technology, online technology, it seems like, I do not know, Prof. Jacobs, what do you think about this? But I think that now when we are facing COVID-19 with online working hours, it seems like we were working 24/7 a week. So we have no rights. We don't apply for a leave, because if we apply for a leave or medical leave, it seems like, why do we have leave? Because you still have to see your WhatsApp, your message, and then your email. So I think it's not sustainable. We have to take our self-care, mentally and physically. It is not sustainable. Even me myself, I cannot refrain myself from working 24/7 a week. So that is the I think the drawbacks of the technology when we are not using it in a sustainable manner. Thank you, Ms. Irawati.
Thank you, Doctor. So there are many more questions. How about I raise all the questions, and then after all the questions asked to the speakers, you can answer the questions after all the questions arise. Is that okay with you? Yeah, so now for Dr. Siti Hafsyah Idris, the question comes from Juan. Will the farmers with their traditional method of farming in the future get forced to change into cross-pollination method using GM of farming since biotechnology getting more popular? Will farmers survive? So that's the question from Juan, and the second one comes from Eli Sari Gulo. So the first one is what is the role of Indonesian government towards Indonesian workers working in Malaysia? Because in the last few months, about the last 6 months, there have been 3 people who have experienced violence, up to the murder, 2 people from, so this is actually is not related with your presentation, but would you like to answer the question, Doctor? It's about the violation faced by the Indonesian workers in Malaysia.
I'm not in the capacity to answer that question because that one is on the, but as far as I know that all people, no matter whether they are actually migrant workers, we have the equality, we have the equal rights here. Even when we doesn't, even the law is actually our criminal law is actually, we do protect not only our citizen but also our migrant workers. Okay, be it illegal or not illegal. Okay, if for example, it has been abused by the employer. Yes, we do. Upon report, they will be charged to the court. Okay, and then with regards to student, I'm in charge of student affairs previously. I'm in charge of students, international students, and we do not have a problem with that. In fact, they are staying in the condominium that is actually within their. They don't have to pay. We do have a reciprocal agreement between the university, and then this condominium, if you may see, is actually apartments. It's apartment, a fully equipped apartment with the air conditions, with the with all the necessities in the house. They have the rice cooker. They have their own rooms, and then for them to go to the class, they have their own bus to go, transportations. And we always maintain and always go to check their welfare. And then we have a groups, and then to make sure that they are well equipped and then well protected in the university. And all our students, international students actually, and not only in UiTM, in my university, but also in other universities, they are well protected. There is no cases of abuse. And in fact, during Ramadan last year and also this year, This year, no, because we already returned all the students. And when they want to return to their country, to Indonesia, for example, actually is on their own willingness. They apply to us to return to their countries, to Indonesia, because they think that it's not safe to stay here because of the COVID-19, and then they rather be with their family in Indonesia, because the class is actually online. So it's on their own voluntary basis to go back to Indonesia, and we give them an option whether they want to stay here, they can stay here and then do the online learning from their condominium, from their house. And then, in fact, we always, during the pandemic, the lockdown, we send foods every day to their house. And I've been the liaison officer for international affairs, I think, for more than 6 years. So that is what I've been doing, not only me, but all the team from the international office and also from the student affairs. We really appreciate them. Then we take care of them as if we take care of our own students, and not only in UiTM, but also, as mentioned, in other universities in Malaysia. So I hope I really answer your question, Miss Ilisari. Okay, and then yes, we do have a bilateral relation between two countries. And to answer this question, as mentioned just now, human rights, okay, we always protect the human right in Malaysia. And then the role of enforcement, yes, as long as there is a report, the police officer will take the report, and then we will actually investigate the case, and then we'll address the case. This is to answer that question. And then with regards to the traditional method, whether the farmers will be forced to use GM crops, I don't think so. It is an option for the farmers. The option for the farmers, whether they want to opt for the GM crops, or they can proceed with their traditional crops. But bear in mind, when one fields planting the GM crops, this is the issue. When we do have two different fields planting a different crop, it can cause cross-pollination. That is why we need a protection for these conventional farmers. And also how do we want to have a situation to integrate the technology with the traditional knowledge, so that all the farmers will be protected. That is my answer.
Dr. Siti Hapsyah Idris. Professor Jacob Berkizen, we have some questions for you. So the first one comes from Hari Budi Arto. He wants to know more about, did the crime rate increase or decrease during the COVID-19 pandemic in South Africa?
That is such a good question. And unfortunately, my answer is it increased. South Africa already has a huge crime problem. But during the 2019-2020 crime stats, what we found is even during lockdown, murder has increased by 5.8%. Rape, sexual victimization, and gender-based violence also increased. Now, if you look at South Africa and what we did for lockdowns, we at level 5, we were not allowed to leave our homes. We were trapped in our homes for a couple of weeks. You could only leave your home to do some essential shopping, and then you had to come back. So if you were a female already in an abusive relationship, I mean, the effect that would have on rape and stuff like that, and murder, of course it would increase. Certain crimes went down, hijacking went down because no one was driving around, but violent crimes increased. And one can think about that also in terms of the lockdown. The more time you spend trapped in a house, just think how irritated you become the whole time, seeing the same people doing the same things, having the same financial stressors over and over. So people are becoming more aggressive and more angry. So unfortunately, our certain crimes shot through the roof and certain crimes went down. But that doesn't mean that we shouldn't analyze and not stop thinking how to prevent this. If the pandemic continues, how will we address these people trapped in their homes, people working 24/7 online? We have to start thinking about how we can make this aggression people feel, this fear people feel, a little bit less. I hope that answered some of that question.
Thank you, Professor. So there are two more questions, I believe. The first one from Saksi Wahyu. His question is that most people know about what is the dark web and deep web on internet, that it's full of criminalization. Why the world or United Nations or all country or all international organizations can't stop that activity of dark web and deep web? If the world let this web to grow up, then how can the world can be better and reduce criminalizations? So
that's also a very good question. And basically it's got 2 points that how do we prevent or make the dark web grow less? Funding. Why aren't we doing it? Funding. Who funds this? Will it be members of the UN? So all countries, how much? And then who will be in charge of that? Again, will it be the UN? Will we have a separate body that goes into the dark web? Then territoriality. And this is such a thing now in international law as well. We would need a dedicated international law that deals with the dark web. The problem is there isn't a international cybercrime law yet. There was an idea in front of the UN, but that was driven by China and Russia. Now, America would not back that, and for certain reasons, I would not as well. So we need a apolitical international law that deals with cybercrime and the dark web. And then funding. All countries would need to invest in infrastructure for their police to be able to go into the dark web, be connected to all other police around the world. For in case if, for example, I'm on the dark web, I commit fraud in Indonesia, but I'm in South Africa. Who's got jurisdiction? Is it the victim that's in Indonesia, therefore the court case should be in Indonesia? Or will it be South Africa because me as an offender is sitting in South Africa? So we have to figure out jurisdiction. We need international law, a fundamental international law that would deal with that. Yeah, thank you.
So thank you, Professor. Before we go to another question for you, Professor, we also have a question for Dr. Siti Hafsah Idris. So the question is there any findings that the GMC cause toll of COVID-19 get worse effect? So is there any findings about that, Doctor?
Is there any finding about
COVID? Yeah, from the toll of the COVID-19, because they consumed genetically modified crops probably.
Okay.
The effect getting worse than probably without they consume that.
Oh, not yet. Not yet on that issues.
Not yet. Okay.
There's no
thank you so much.
Okay, thank you. There's no study yet on that. Yeah. And then it means that when they consume the GM food, their symptoms become worse. Is it your question? Okay, there is no study yet. And then the findings on the impact of GM crops on the COVID-19 cases, not yet.
Okay, thank you, Doctor. So now I will read a question for Professor Jeko from Ibu Industri Utari. Her question is that we know that the COVID-19 pandemic has had a huge impact on all aspects of life. So how does this look from the perspective of victimology?
Okay, that's a very interesting question. And I can talk about that for another 7 hours. So, but I'll try and nutshell this. So what we found internationally is there has been a growth of gender-based violence. There's been a growth of the use of technology to victimize people. Rape and sexual abuse have increased. Human trafficking has decreased a little bit, but that means human trafficking between states. So from South Africa to Indonesia, or from South Africa to Malaysia, or Malaysia to South Africa, that is reduced. But state human trafficking still stays the same. It depends on the lockdown levels for each country. Then what we also found was that, terrorism and terror recruiting has increased. So in one hand, the pandemic has lessened certain crimes. Housebreaking, for example, has gone down, but interfamilial murder has gone up. So on one hand, the pandemic has lessened victimization of certain forms of victimization, but it also increased certain other forms of victimization. And the more we look, we're going to discover new types of victims after this pandemic, or victimizations that we never thought of existed. For example, overwork, being a victim of overwork. This happens in South African academia as well, as the professor said. You feel too guilty to take leave, even if you're sick, because you get WhatsApp, you get email over Saturdays from your bosses. So victims of overwork, academic burnout, all this will be part of a whole new post-COVID victim studies that we will have to look at. Thank you.
Sorry. Yeah, so we have another question from Juan Antonio for Professor Jaco Barkizan. In your opinion, how the algorithm or AI or with machine learning recognize the victim's position with severe autism spectrum disorder or ASD in victimology?
Well, that is such an interesting question as well. The rise of machine learning and AI, and also with apps that give psychological comfort to people. It would be soon that we will have algorithms that will be able to diagnose, that will be able to give primary psychological therapy. I'm not saying we will never need a psychologist or something like that, but imagine you're in a very rural area and something traumatic happens and you cannot reach your psychologist. There's an app. And I think eventually, because to diagnose someone, you need a criteria list. And eventually AI or machine learning will pick up through a programmed criteria list that this person might have this or this person might have that. But again, with technology the way it is, the interconnectedness, if you're on an island somewhere and you need to speak to a psychologist, if you have a data connection, you would be able to. So anything is possible. It really depends on who's going to program it, but that would probably be the future. Thank you.
Professor, this time the questions come from Dr. Industri Utari. She would like to ask a question to both of you, for Professor Jacco Berkiezen and Dr. Siti Hafsia Idris. Her question is, according to your academic perspective and you as human, would you agree that we all have to accept vaccine as solution for the COVID-19 pandemic? And then, as for we know that many countries that force their people to be vaccinated, although we have several cases that many people had died or ill or get infected by COVID-19 or even after they were vaccinated. So is it a crime to a state to force their people to accept vaccination? So, that's the question. So yeah, probably Dr. Siti Hafsia, you would like to respond first?
I think this is the area of Prof. Jacob on human rights and criminology. Perhaps you can answer it first.
Okay, Professor Jacob.
Okay, from my point of view, let's talk about it. If you want to travel the world over, if you want to come visit South Africa, for example, or you want to go to Kenya to see the Great Migration, you will need a yellow fever vaccination before you're allowed to travel. So, or else you might get yellow fever, right? Before you come to certain parts in Africa, you need to have malaria medicine. So I don't see it as a problem of taking a vaccine. On a personal level, I would like to travel to Indonesia one day and to go visit my children that's trapped in Japan at the moment. And the only way I would be able to do that is to get my vaccine, because travel restrictions are the way they are. You will need a vaccine to travel. Same with even before COVID, if you wanted to go to certain parts of the world, you would need to get either a yellow fever or a typhus or whatever vaccine. This is just an extension of that. So I would say it's a human right to have a vaccine. Remember, there is disclaimers on that. If you have certain allergies to certain chemicals in the vaccine, you cannot be forced to take it. But if you have comorbidities and taking the vaccine will actually help you not getting sick, then take it. I can't wait for my vaccine. I don't care which one it is, as long as I can get the vaccine and then start to travel. I used to go, 3 times a year to Indonesia. Now I'm stuck in South Africa. It's depressing. I can not go see my kids because Japan won't allow me to enter without the vaccine. Same with, I can't visit my friends in England if I don't get a vaccine. And this is just how the world's going to be until this whole COVID thing has ended. And the only way that's going to end if people take their vaccines, those that are allowed to, those that can. In terms of ethics, it has to do with the whole idea of herd immunity. The more people that have been vaccinated, the less likely it is that we'll have a COVID-20 or a COVID-22, because more of the people in the world will be vaccinated against this. And just think how amazing actually technology is when you think about the vaccines. Last year, this time, we were all freaking out thinking this is the end. This is like the Spanish flu of 1917, which there is no cure for. But in a few months, people got the biggest and brightest brains together. And now we have actually not just one vaccine, but a couple of vaccines that can potentially stop this. So in my opinion, I would take the vaccine. I'm not allergic to any of the ingredients, so I'm okay. And then I can fly and visit you guys, and I can visit my kids. Thank you very much. I hope that answers from my perspective.
Yeah, thank you, Professor. We are looking forward to meet you in person actually in Indonesia. Hopefully, yeah, soon you can travel back. Yeah.
So I'm also agree with Prof. Jacob, because with vaccine, actually now every country actually, when they want to leave the travel bubble, we need to be vaccinated before we can enter to the country. And then in fact, if we want to go back to the normal life, like what happened in US, in UK, now they don't have to wear the mask. They can do their daily life as before COVID-19. That is a good thing about that. And I don't want to say that we need to, even in Malaysia, actually, even the Majlis Fatwa, the religious group, also they said that we need to have the vaccines, because why? We need to go back to our normal life. We need to go back to mosque. We need to perform our prayer together with the others. We need that. So how actually we want to prevent? This is actually our own initiative, our ethical issues, to not only for us, but also we do not harm other people. So at the moment, yes, there is no criminal offense for that. And then we also do not want that to happen to other people, because that will create another situations. But I think it's go back to our self-awareness and also our ethical and also legal obligations to take care of other people's lives, not only our life, but also our other people's life. So it's go back to our human rights basis. We have to remember not only us to have human rights, but also we have to respect the other person's life. Thank you.
Thank you, Dr. Siti. So the perspective of human rights, we need to lay it down first before we think that it's our human rights to say no for the vaccination itself, but how to protect others. Probably that's important. Yeah, so another questions from Toha Masrur to Professor Jeko. COVID-19 originating from China. In China, COVID is seen as progressing. It's safe, but the problem is why and how to deal with in other countries such as Indonesia. And the discourses are no longer dealing with the virus, but on the other hand, it is in the realm of politics, economy, and etc. So probably the question is that it's not just about health problems, but it also, have already gone to politics and economics. So Professor.
Well, yeah, no, this is true. This is true. Remember, COVID is a health problem, but first of all, the reaction was political. Most countries did what? Lockdown, right? Malaysia, Indonesia, South Africa. How countries did the lockdown depended on their political ideologies, right? Now, lockdowns had an effect, and it had a wide-ranging effect. It had an economical effect. People lost their jobs. People got paid less. Businesses closed. The black market in certain goods exploded. So yes, it is a health issue. But remember, health issues have consequences. And even in Indonesia and even in South Africa, it has had a political consequence, an economical consequence, and even now a social and academic consequence. We're sitting talking in a conference, not at a hotel, but in my room and in my study, and my colleague in Malaysia is in her area. And I mean, we're not in Indonesia. So that's the consequences. And it's neither good nor bad, but how we react. We need to hold governments accountable for their political decisions that they made during COVID. I mean, we have to talk about how far can you take a natural disaster legislation or state of emergency before it completely infringes on human rights. How far can we enforce human rights during a pandemic, like the question about vaccines. Would it be human rights to force everyone? That's possible. Or shouldn't we still make it a choice? See, so this is the debates we should be having, because yes, it's a medical emergency, but it has bigger world implications, political, economical, social. And we need to be cognizant of how that interplay actually affects our daily lives. Thank you.
So thank you, Professor. We have another question for you, Professor. It's in regards with your speech. So the question is that is your country, South Africa, has had a law regime or legal system to overcome the technological-based crime? So
okay, so I was in a meeting with the South African police a month ago, where the police discovered that in 2020 we actually have a cyber crime act. The police didn't know that. So, you know, it is, again, we have the laws, we have the regulation, but what happens in any government, whether it's South Africa, Malaysia, or Indonesia, sometimes there's a disconnect to what is in the law books and what the police understand is in the law books, or what Parliament understand is in the law books. It's sometimes this communication disconnect. You might have Parliament passing a law, but the police maybe not know about it until a lot later. And that has to do with just humanity and communication levels and stuff like that. Even now, how do we enforce a Cyber Crimes Act? One of the questions that I asked you guys were, if I commit a cybercrime fraud against someone in Indonesia, who's got jurisdiction? And this is something that we still need to discuss. If the victim is in Indonesia and the offender is in South Africa, which country can prosecute? Will it be Indonesia because the victim is there and the money was stolen from Indonesia? Or is it South Africa because the offender is in South Africa and the money came to South Africa? You see, this is so interesting. And this is something that some of the legal students should actually think about. Where do we place this? Where's the victim? Where's the offender? Who gets to go after? Who, will it be the country with the victim or the country with the offender? So we need to still debate this and talk about this. South Africa says if the victim is in South Africa, then the South African courts have jurisdiction. Now, the problem with that is, and one of the questions to my colleague was about, what about victims in Indonesian victims in Malaysia? Now, usually countries have something called MLA, Mutual Legal Assistance. Now, not all countries have MLAs with other countries. So if something happens in that country, for example, if you're in South Africa and you are a victim in Indonesia, the consular services will help you. Or if you are accused of a crime in Indonesia, then the South African consular services can get you a lawyer and assist you. But not all countries have these MLAs when it comes to crime and assistance. So this is more of an international law framework that we need to develop with MLAs in terms of crime and cyber crime and cyber victims. Who's got jurisdiction? And who's the guy who's gonna sit in judgment? South Africa uses a very similar system than Indonesia and Malaysia when it comes to criminal law. It's a Roman Dutch Westminster hybrid system because we were colonized by the Dutch and then we were colonized by the Brits. So we've got this Roman Dutch system, but also common law. So we have this hybrid system. And the same with Indonesia, where you also have a Roman Dutch and then a common law sort of thing thrown in there. But not all countries have that. So again, it comes down to we need an international law and oversight on something like that. Thank you.
Thank you, Professor. To Professor Dr. Siti Hafsyah Idris, there is a question. It relates to the customer who buys the genetically modified crops. Is there any like a system or probably a regulation who that ask people who sell GM crops informs their customers that actually the crop is genetically modified?
Yes, we do have that on labeling. Labeling law.
So how about if there is any label? Is there any punishment for the seller probably?
Yes, there is a punishment whereby they need to be labeled and then need to be go through the process. The label, when they want to apply for the labeling, they need to go to the certain department for the approval. And if they don't label their products, then it is actually an offense under the Act.
Oh, right. Yeah. Thank you, Doctor. So back to Professor Jeko Barkizan. So in relations with the criminology regarding technology, do we need a new kind of punishment? Not only probably conventional punishment. So that's the question.
Okay, I don't like the idea of punishment. I'm against criminal sanctions. I'm more for restorative justice. We need to understand why someone committed a crime, and we need to understand how that crime affects the victim. We need to have a restoration between the victim, the offender, and the state. Punishment has not worked. If you think about it, it has not worked. If punishment worked, then we only had to convict one guy of fraud. We only had to convict one guy of murder and no one else would have done, right? The same with the death penalty. We should have only killed one person and you would have no murders because people would be too afraid of being punished and getting the death penalty. And that's not how humans work. We always think we're smarter and better. So I'm not for punishment, but my idea is that we have to bring in the restorative justice more into a criminal or into a justice system. First of all, we should do away with this idea that we call it a criminal justice system. Putting the criminal in front of justice means more it's towards the criminal. It should just be the justice system. And we should rethink how we view justice. Because the justice system is there. How it was envisioned by Beccaria was to give voice for victims of offenses. But it's now been perverted where you have Lady Justice with the two scales, right? One scale is for the rights of the state and one scale is for the right of the accused. But nowhere is there a scale for the rights of the victim. In the whole criminal justice system, in a trial for whatever crime, the victims are basically just evidence. Only a year after conviction do we usually bring in victim impact statements. How did the crime impact you as a victim? Nowhere during the trial can a victim actually, in a normal criminal justice trial, can the victim actually just ask a question to the offender as to why did you do this to me? We don't have that. Germany has something like that called the Nebenklage system, which is a brilliant system where the victim can bring in their own lawyers to ask questions during a trial. But that is something that we need. We need to be more restorative in our approach than just punishing. Because punishment's not helping, it's not working. If punishment worked, we would have no crime whatsoever. Like even when you were a naughty child and your mom hit you, did you really stop being naughty, or did you just find a better way of hiding being naughty, right? It doesn't really happen. It doesn't really work. We need to be smarter. We need to be more in tune with what the reasons is behind why people do what they do. I hope that answered the question.
Thank you, Professor. So if I am allowed to extend the question, because I understand that your background, one of your educational background is psychology. Could you please probably tell us more about how to probably not punish, but how to treat the people who conduct crime in relation with technology?
Okay, to understand why people commit crime, we have to look at motivational factors. What motivates someone to commit a certain crime, right? There is no one answer fits all. So you have to actually understand the motivation behind the victimizer, right? Is it socioeconomical? Do they come from a poor background? Is it more because of psychological issues? The moment we understand that, we can address our therapy or intervention or punishment to fit the person. Because a one-size-fits-all solution is not working. It just leads to more prisons and bigger prison population and less rehabilitation. You know, so we need to psychologically understand the motivations behind why someone commits a crime, specifically to that person, and then fit our model to that person. And for that, we need to be more proactive in how we write laws, how we view deterring crimes. You know, it's a big thing. Just thinking like this person stole money, so we need to give him a minimum sentence of this. But why did the person steal money? We never actually think behind the motivation. And that's only a small part when we look at a criminal trial. Mitigation of sentence is only a small part of a trial. So you get convicted and then, yes, he stole the money. And only then do we look afterwards. Okay, so he stole the money because his family was sick and he didn't have enough money to take care of his family. So we're not going to give him 5 years. We'll give him 3 years for the theft. You know, that doesn't really help. That doesn't work. We have to rethink justice. We have to be more person-centric. We have to have a person-centric justice system. Person-centric in terms of the offender and person-centric in terms of the victims. I hope that helps.
Professor, so yeah, it can be only from one discipline, but it has to be from multidiscipline or even interdiscipline. Probably that's the better way. So before we end this panel, I would like to ask Professor Jacco Berkhuizen and Dr. Siti Hafsah Idris to give your final remarks for our audience. So we start with you, Dr. Siti Hafsah Idris. Please.
Thank you, Miss Moderator. Apa yang kita panggilnya yang cantik sekali, Miss Irawati. Thank you for that.
Very beautiful.
Okay, thank you for that. Okay, first of all, I would like to thank again to the organizer, okay, to Bu Dekan, Bu Radia, for inviting me as the speaker for this event. And then I would like to say that yes, we need development. Okay, as I mentioned just now, we need development. But in order for us to balance the development and also to environmental protection and also social justice and equality, we need to balance it in a sustainability manner. So I know that we cannot stop the development, especially with regards to GM crops, with regards to GMO, and that it will eventually affect the livelihood, the rights of the human, the rights of the farmers. But we need to develop, we need to leverage the skill and also the knowledge in more innovative way that can mitigate the risk to the environment and also the risk to the human life and also the animal's life. I think that's all from me. And yes, over to you, Ms. Irawati and Prof. Jacob.
Thank you, Dr. Siti. Professor Jacob, we looking forward to your final remark, please.
Thank you very much. First of all, terima kasih for having me. I really enjoy interacting with my Indonesian colleagues and colleagues from all over the world, even though I'm stuck in South Africa. My final thoughts is we need to remember technology is humans. Humans is technology. We're the only species on the planet that actually evolved by using technology. And we're the only species that have something called a justice system, right? So we should always be cognizant as people evolve, as societies evolve, as humans evolve, technology will evolve with it. The idea of justice will evolve with technology and with humanity. And we need to always, like the doctor said, we always should have social justice as a core of this evolution. Yes, technology can be good. Yes, technology can be bad. But if we have that social justice core, it will be more likely be good than bad. We need to help more and destroy less, if in a nutshell. And how do we do that? By putting humanity and human rights at the core, that whole idea of social justice at the core of what we do. Thank you.
So thank you very much, Professor Jacob Berkhuizen. One more time, thank you so much, Professor Jacob Berkhuizen, Dr. Siti Hafsyah Idris, for finding your time to join our seminar. And I would like to thank also to our wonderful audience, especially who has raised question for the speakers. So it's lovely, and I'm looking forward to see you soon. Actually, I would like to come to Malaysia again, Dr. Idris.
Yes, soon.
Yeah, thing in my bucket list, actually, Professor Jaco, I would like to go to Africa. It is wonderful there. So yeah, we also welcome you both to our university.
Inshallah soon.
Yeah, so thank you so much. I apologize if there is any inconvenience along this seminar. So Imam and Intan, back to you.
Thank you.
Thank you.
Give applause to Ms. Irawati and all the invited speakers for the second panel. And ladies and gentlemen, we have now come to the end of the opening ceremony of 4th ICILS, and we would like to extend our gratitude and thank you to the Rector of Universitas Negeri Semarang, the Dean of the Faculty of Law, and all the invited speakers for your endless support. And thank you again for all the participants for your support on this conference.
Ladies and gentlemen, we will have some information for you. Tomorrow we will meet you again at 9 a.m. in the Zoom meeting, of course. And please rename your Zoom ID with your chamber room _ your name. Remember your chamber room and your name, okay? And see you tomorrow. Don't forget to stay safe, stay healthy, and see you. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam.